Morning. I'm Dr. Howard Kraus, Chair of Panel B. My agenda items indicate a 9 a.m. start. Some other people have seen some materials that indicated a 9:15
Mine said
start.
9:15. I got one that said 9 and one that said 9:15 after that. I'm ready.
If all assembled are prepared, we may start at this time. I'd like to introduce Administrative Law Judge Jill Schlichtman.
Good morning, everyone. All right.
Actually, I should have asked for a roll call first. I'm sorry.
Dr. Kraus,
Present.
Dr. Bolat,
Present.
Dr. Nanadev,
Here.
Ms. Lawson,
Here.
Dr. Levine, Ms. Pines, Ms. Sutton-Wells.
Here.
We have a quorum.
Thank you. Judge Schlichtman.
All right, thank you. Good morning, everyone. Let's go on the record before the Medical Board of California in the matter of the accusation against Elsika Sagi Shaham, MD. This is Office of Administrative Hearings, case number 2015-07-0757, and board case number 17-2013-235259. Today's date is July 28, 2016, and we are here in South San Francisco for the hearing on the non-adoption of the proposed decision in this matter. I will take the appearances of counsel at this time, starting with Complainant's Counsel.
Good morning, Cindy M. Lopez, Deputy Attorney General for Complainant.
Good morning. Albert Garcia appearing for the respondent, Dr. Shaham, who is present.
Good morning.
Good morning.
All right, I'd like to remind everyone that the purpose of this hearing is simply to argue the evidence that is already in the record rather than adding new evidence. And I'd also like to remind the parties that the respondent will begin with 15 minutes. We'll keep a close eye on the stopwatch, so please don't go over your time limit or I'll have to interrupt you. And then followed by Complainant's Counsel for 15 minutes, and each side then getting closing argument for 5 minutes. And Mr. Garcia, I understand that Dr. Shaham has chosen not to address the panel directly. You'll be handling the argument.
I will, Your Honor. Thank you.
Okay, perfect. All right, then I will invite you, Mr. Garcia, to address the panel at this time.
Thank you. Just a question here. Is this a timer here in front of me, or are you going to give me the time?
I can.
It doesn't matter. It just says 3 minutes right now. So. It doesn't matter. You could just signal me. It's okay.
Okay, would you like me to let you know when you have a couple minutes left?
I'd appreciate that.
All
Thank
right,
you.
I'll hold up my hand. Okay, go ahead.
Thank you very much. Good morning. I want to start by referring to a very, very recent case that I think is very important for the issues that we have to determine here today. And the case, which was decided in the late June and just certified for publication on July 11th. So, Your Honor, there is no reporter's citation to it, but I will give you the name of the case and the docket number. The case, and I'm sure that the board is aware of it, is Amir, A-M-I-R, Peruzian, P-I-R-O-U-Z-I-A-N, Second Appellate District, Court of Appeal, California, docket number B as in boy 266015. And the reason I want to refer to that case is that, pardon me, it involves a writ of mandate that was issued by the Court of Appeal, setting aside a revocation that had been ordered by this board. And
I'm sorry, Your Honor, I don't mean to be rude and interrupt, but I haven't seen this decision, and obviously it's going outside the record, so I'm not sure if the panel needs to hear about this.
Well, it's not new evidence, it's just legal argument, so I'm going to allow that.
thank you very much, Your Honor. And the decision reminds us, of course, that what the purpose of discipline is. And it reminds us of the adage that punishment is not the goal. And it indicates here that although the board has discretion in determining the discipline to impose for unprofessional conduct, such discretion is not whimsical, uncontrolled power, but a legal discretion which is subject to the limitations of legal principles. Now, I'm going to refer to three factors that the court looked at in setting aside that decision because those three factors are squarely applicable to the facts that we have in this case. And I'll get to those in just a moment. But in setting aside the discipline in the Perusian case, the court first noted that the misconduct there had occurred over a discrete period of time. Second, it took note that other than the misconduct involved in that case, the respondent there of the Dr. Perusian had an otherwise unblemished professional record with no disciplinary history. And finally, the court indicated there was nothing in the record to indicate that Dr. Perusian would ever reoffend. So the Court of Appeal there focused on the purpose of discipline, saying what is necessary when you impose discipline, what you're looking at is what is necessary to protect the public health, safety, and welfare. In this case, the administrative law judge who heard the evidence over the course of a 3-day hearing and was able to assess that evidence firsthand, of course, made a determination that a public letter of reprimand would be appropriate to protect the public health, safety, and welfare, and that probation was not necessary. That probation would not be necessary to protect the public interest. That was a determination made by the ALJ after hearing and assessing all the evidence. Now, what was that based on? Obviously, we have a rather long proposed decision with many factual findings, but I'm going to refer you to what I believe is the linchpin factual finding upon which the proposed disciplinary order was based. And I refer you to factual finding number 32. And here, the administrative law judge, incidentally, that was Judge Dash, indicates respondent has practiced for more than 30 years. That's in the record. And up until 2012, he was a board-certified OBGYN. That was his practice. And then he went into semi-retirement in 2012 and ventured into this area of recommending marijuana for medical purposes. And by the way, the accusation in this case and the decision is based on two recommendations made in the year 2014 to two undercover officers. But anyway, factual finding 32. Respondent has gone back to the practice of obstetrics and gynecology, but whereas he used to deliver 50 to 70 babies per month, he now delivers less than 10 babies per month. He goes on to say, and this is really crucial to his determination that a public letter of reprimand was appropriate to protect the public interest. The ALJ says, official notice is taken that the care and treatment of pregnant women and the delivery of babies requires a high degree of patient management and skill, the utmost diligence in performing physical examinations, and the preparation and retention of extensive medical records. After more than 32 years in practice, respondent has no history of board discipline. And by the way, the record also indicates that Dr. Shaham still maintains privileges at Hollywood Presbyterian Hospital and Good Samaritan in Los Angeles. So, going back to the Perusian case and the factors that were looked at there, a discrete period of time, the misconduct occurred over a discrete period of time. After 30 some odd years of practice, Dr. Shaham goes into recommending medical marijuana on a part-time basis in semi-retirement. He makes two recommendations over a period of 2 months. That's it. You look at his overall professional career spanning 33 years, and you see two incidents occurring 2 years ago, a discrete period of time. Number two, an otherwise unblemished professional history. And again, remember what Judge Dash is saying here when he's taking official notice. He's saying, look, This doctor has practiced for 32 years in a very exacting, a very demanding area of practice, OBGYN, which requires, as he indicated, a high degree of patient management and skill, the utmost diligence in performing physical examinations, and the preparation of medical records. Now, those are important because those are issues that came up in this case. In this case, it's alleged that the marijuana recommendation was issued without having conducted an appropriate physical examination and that the documentation was subpar. So Judge Dash is saying, look, this man has practiced in a much more demanding area. He knows how to conduct physical examinations. He knows how to maintain records and obtain histories. It's not that he doesn't know it. He knows it, because otherwise he would have gotten himself in trouble a long time ago. And he didn't. 32 years, unblemished history. And also, there's nothing in this record, as in the Perusian case, to indicate that Dr. Shahan will ever reoffend, because, as Judge Dash notes, he went back to practicing OBGYN. That's what you're looking at. Now, obviously, this board decided against adopting that proposed decision. And I mention here that in doing so, I think that the old adage that we hear all the time that discipline is not to impose, it's not for purposes of punishment, I think it's put to the test here. Why else would you impose more discipline on this particular doctor? You have a very experienced, competent doctor. And the two incidents that occurred here in that very discrete period of time were obviously and clearly aberrations. That's the way Judge Dash looked at them. So what probationary conditions would you impose on this particular doctor to protect the public interest and make him a better doctor? Now, I kind of made a tongue-in-cheek remark there in my written argument, and I indicated, look, it's not like Dr. Shahan woke up one morning in 2012, that's when he started recommending marijuana. He woke up suddenly forgetting how to conduct physical examinations and how to obtain medical histories and how to document them. That couldn't have been the case. So what kind of conditions would you impose on this doctor to protect the public interest and make him a better doctor? I can think of none, and ALJ, Judge Dash, could discern none, and that's why he indicated that probation was not warranted. Now, how much time do I have, Your Honor, by the way?
You have another 5 minutes.
Okay, well, I'm going to be very brief, obviously, I have no choice, and indicate that because the order for non-adoption indicates that the board would look at the entire case, I do think that I would like to spend a little time just indicating that there's some issues in this case that I think should be taken note of. And one of them has to do with the legal issue of whether marijuana could be recommended to patients who do not suffer from serious illnesses. Now, I briefed that extensively in the written argument, and my expectation is that you read and looked at it and considered it. It's a very important issue because the expert in this case said, look, you can't even recommend marijuana for anyone unless that person is seriously ill and suffers from these serious medical conditions. And as I indicated in the written argument, the term seriously ill has been read out of the Compassionate Use Act by the courts of the state. And I know the argument is, well, those were criminal cases. I understand that argument. But there's nothing in those decisions, in those holdings, that make that interpretation specific to criminal law. It's just that the courts were looking at that language and were saying to themselves, is this part of the act, or is this a prefatory statement, a preludial statement, an introductory statement, if you will, which does not really fit into the substantive part of the statute and therefore does not limit the protection of the act to seriously ill Californians. So that's a legal issue that I think is very, very important, and it might go up on judicial review depending on what the outcome of this hearing is. And the other thing is, I think there were some serious credibility issues with the two undercover agents. You must remember that the whole case here has to do with what those undercover agents said occurred during their consultations with Dr. Shaham. It's a he kind of situation. You know, he said. And so their credibility becomes important. And one of those officers testified that when he went for his undercover visit, he saw juveniles in the office. Now that's important because this whole case started with an anonymous complaint indicating that Dr. Shaham was recommending marijuana to the kids in the valley, San Fernando Valley. Kids in the valley. That's what started this investigation. So he goes in there and he testifies under oath that he saw juveniles during his undercover visit. But in a declaration that he prepared immediately after his visit, he says nothing about it. In the investigation report that was prepared in this case, all part of the record here, there's no mention of any juveniles being in that office. So how, as I sit here and as you sit there, if you have an investigator who goes in based on a complaint that kids are receiving recommendations and he observes them in that waiting room, wouldn't you think that that would be something he documented in his declaration and would be included in the investigation report? It was not. And yet he got up on the witness stand and testified under oath that he saw juveniles in there. That's incredible testimony. And under the law, thank you, under the law of evidence, if a person testifies falsely as to part of his testimony, the trier of fact, and this is the tribunal here, the ultimate decision maker in the case, can disregard his entire testimony. And there were other problems with the other investigator as well, not as blatant as the one I just mentioned, but that one is clearly blatant because if you go in there based on an anonymous tip that there are kids getting recommendations, you would think that if you actually saw the kids there that you'd make that a big point in the case and put that in your declaration, put that in your investigation report, and as this board can see, there wasn't even an allegation in the accusation that juveniles were getting these recommendations. So that didn't bear out. It didn't pan out at all. And for him to get on the witness stand and say otherwise, I think speaks volumes about the lack of his credibility. And this case has to do with what he said occurred in the privacy of his consultation with Dr. Shaham. Your Honor, I'm going to reserve the last minute or so for my rebuttal. Thank you very much.
Okay, thank you very much. All right.
No, I think we should proceed.
All right, Ms. Lopez, your argument?
Good morning. As the panel knows, the issue in this case really comes down to the discipline, but I do want to respond to several of the arguments that respondent made in his brief. And without being disrespectful, I feel like I was at a completely different hearing and read a completely different proposed decision based on his brief. So he starts out with Judge Dash, the ALJ, and he says that Judge Dash saw and understood the aberrant nature of the claimed deficiencies, and he saw no public interest in proposing probation. He points out that an agency may not disregard an ALJ's credibility findings unless there's substantial evidence of the reliability of that testimony, and he goes on to say the ALJ did not get it wrong. He makes an even more interesting point when he states that the ALJs must be members of the medical quality hearing panel because they have more training, they're more experienced. So, as an experienced member of the panel, you must accord great deference to Judge Dash's findings. I totally agree. What's interesting is respondent fails to point out that every finding went against him except the very, very last paragraph. Judge Dash did not find respondent's expert credible. He did not believe respondent when he testified that he performed physical exams. He found him to be dishonest. He found his record keeping to be inaccurate. Those are the credibility findings that I agree this panel must give great deference to. Now let's talk about the standard of care because I agree with Mr. Garcia, it's very important in this case. The standard of care, and this is at page 7 in the proposed decision, it talks about the Compassionate Use Act. The term seriously ill, as used in the statute, is not specifically defined, except by example. These examples evince a legislative intent that medical marijuana is to be recommended not for any condition for which it might provide some relief, but rather for conditions that cause substantial pain, disability, impairment, handicap, and the like. The expression, quote, any other illness for which marijuana provides relief, unquote, means, quote, serious illness, unquote, by the use of that term earlier in the same subdivision, and is evidenced by a list of examples of medical conditions. Now, I realize that this is getting in the weeds of legal analysis, but what he's saying is that there has to be a serious condition, not just something that marijuana can provide relief for, which is what Respondent has argued. Now, in his brief, Respondent is just plain wrong. Now, I find it interesting that he finds Judge Dash correct on his finding that a PLR is appropriate, but never once in his brief does he mention that Judge Dash believed complainant's expert regarding the interpretation of the standard of care. Respondent argued at hearing and now in his brief that the criminal law says that the term seriously ill is not prefatory. Is solely prefatory. It's not. And he cites to a case, and again, I don't want to get into the weeds, but it's talked about in footnote 7 at page 7. Again, on the legal analysis, Respondent is just wrong. He argues and asks, what other evidence did we present on the issue of the standard of care regarding medical marijuana, other than our expert's opinion? Well, none, because an expert's opinion is all you need to substantiate findings. He argues that we failed to present clear and convincing evidence of the standard of proof. When he does his rebuttal, you might want to ask him what evidence he expected us to show. Now, he talks about the facts of the case and the investigation. He argues that Dr. Franklin, who is a complainant's expert, had no experience in recommending medical marijuana. The record belies this. He had 5 to 10% of his practice involves that. Respondent claims the manner in which this was investigated undermines the case. Judge Dash didn't seem to think so. He believed our investigators. He didn't find anything wrong with the investigation. Respondent takes issue with how long the investigation took. So, he takes issue with the fact we got an anonymous complaint. So, he takes issue with the fact that the investigators met at a parking lot after a debriefing. Again, this just turned off. And undercovers do that all the time. After an undercover, they go and debrief. He takes issue with what the investigators testified to. Judge Dash didn't, and he was the trier of fact. There's also this issue of monitoring, which was discussed ad nauseum at the hearing and in the briefs. He takes issue with one investigator saying he had a monitoring device, another one said he didn't, it didn't record. Then Respondent and his counsel accused both myself and the investigators of withholding evidence. Again, the record belies this. And Judge Dash never mentioned it. So if we look at the decision, so again, I'm going by what Respondent argues, having Judge Dash and this panel give great deferential treatment to his findings. Regarding Investigator Boyd, Judge Dash found Respondent did not conduct a medical or physical exam. Regarding Investigator Buscarino, despite performing no physical exam, Respondent recorded in his records that the thyroid was normal, the heart was regular. Giving deferential treatment to Judge Dash, he found Respondent failed to take a medical history from either undercover. Judge Dash found our expert more credible, to the point where he basically copied word for word the expert's report into his proposed decision. I can tell you, after 22 years of doing these cases, I have never seen that. So if our expert was so not credible, why is every single word of his expert report in the proposed decision? Judge Dash found that respondent's expert recanted his testimony by acknowledging that many of the things that respondent failed to do were in fact required by the standard of care. So yes, let's give deference to the ALJ's findings. Now, respondent repeats over and over again, he's practiced for 33 years in a specialty which requires a high degree of of patient management and skill, the utmost diligence in performing physical exams, and this is why he's arguing that Judge Dash did not put him on probation. Here's the problem with Judge Dash's recommendation. So as you're reading the whole decision, he does a fantastic analysis. He finds in favor of every finding in favor of the complainant, yet he issues a PLR but says that the respondent cannot issue medical marijuana recommendations. He can't do this. If you look at the disciplinary guidelines, for findings of gross negligence, which there were in this case, discipline is a minimum of 5 years probation. For findings of dishonest acts, in this case he found that, the minimum is 5 years probation plus suspension time. For findings of failure to keep accurate records, made in this case, the minimum is 5 years probation. For failure to perform a physical exam, again, findings in this case, it's 5 years plus suspension. Again, not to be sarcastic, did you hear me mention public letter of reprimand in that? No. So I would ask this panel, when you look at the guidelines, and then you look at this case, and you look at the findings, unfortunately, you can only issue a probationary order. Business and Professions Code section 2227 allows a PLR to issue with education courses. So in this case, the judge said he needs to take medical record keeping, no problem, but again, he adds the license restriction, and he's not allowed to do that. So in keeping with the theme of respondent's brief, I absolutely agree. You need to give great deference to Judge Dash's findings until you come to the very last paragraph. Now, regarding this case of, I think it's Perusian, I have not seen that case. I don't know what it's about. It sounds like a revocation was overturned, not really applicable to this case. This is not a revocation being overturned. So I'm at a little bit of a disadvantage, so I don't really want to say too much about that. But again, I would ask this panel to look at the order, to look at the disciplinary guidelines, and to rule accordingly. Thank you.
Thank you. Mr. Garcia, you have an additional 5 minutes, so you can start now.
Thank you. First of all, I want to start by saying that I have made no attacks at all on counsel. And every remark I made in my opening statement had to do with factual finding 32 and the Perusian case and the factors that are mentioned there. I have no attacks on counsel. And in fact, if you look at page 17 of my brief at footnote 57, when I'm referring to the withholding of evidence, I say the ensuing remarks concerning the prosecution of the case are intended to apply to the questionable conduct of the board's enforcement unit and the investigators involved in the case, and are not intended to apply to the office of the Attorney General. I make that very clear. So I think that that's an unwarranted kind of attribution that's been made here. Now let me go to the guidelines. What are guidelines? I remember a line from the Pirates of the Caribbean where one of the characters wants to parlay with the captain of this pirate ship, and she says, well, you know, these are rules. He says, no, they're not rules, they're just guidelines. Well, they're guidelines. And Judge Dash, who's been around for a long, long time, I indicated in a footnote, he's been in ALJ since 1988. He knows what he's authorized to propose as a disciplinary order or not. Guidelines are guidelines, and what he did in factual finding 32 is he told you why he was deviating from whatever guidelines might be otherwise applicable. He gave you the reasons for it. So this whole notion of you can't issue a PLR, I think it's incorrect. I think it's well-intentioned argument, but it's incorrect. The board has wide discretion to impose or fashion a disciplinary order that's appropriate for the particular facts and circumstances of the case before it. Now, in the Perusian case, the reason I mentioned that is because the fact that it's a revocation has nothing to do with it. It's a disciplinary order that was set aside because the court there found that there was an abuse of discretion, and the abuse of discretion was based on the fact that the court looked at the fact that the misconduct occurred over a discrete period of time, as in this case. There was otherwise an unblemished professional career, as in this case, and no indication that that doctor would ever reoffend, as in this case. That's why I mentioned it, and I think, obviously, those factors are reasonable to apply in any case, and certainly in the particular facts of this case. So don't be misled by, well, it was a revocation, so it's not applicable. No, the principles involved are what we're looking at, the overall principles. Now, in terms of the legal issue of seriously ill California, I briefed that at length, and the reason I put that in there is, and when I talk about was there any other evidence of the standard of practice, what I was referring to was this. The board's expert came in, and his whole opinion was based on this notion that you have to have a seriously ill patient threshold before you can issue a recommendation. And the argument it's a legal argument, by the way, a matter of legal interpretation, Your Honor. And so there, if the courts have said, no, that's not the case, that term, seriously ill, does not define, does not limit, does not in any way modify the actual terms of the statute, then he was wrong in making that opinion. That was my point, that he was wrong, and there was no other evidence of the standard of practice other than what he said, which I believe was wrong, based on the legal principles that I've cited and discussed in the brief. So, in terms of the factual findings that were made, yes, Judge Dash made these factual findings, but that's not enough. There were factual findings in the Perusian case, dishonesty, and others. And the Court of Appeal did not say, well, we're setting aside those factual findings. That's what the Court of Appeal said. We're saying, we'll accept those factual findings, and notwithstanding that those factual findings were made, the penalty that was imposed was inappropriate. And that's what we're saying in this case. If you impose anything more than what Judge Dash has already recommended, based on his experience, based on his firsthand, in-person assessment of the evidence in this case, if you impose anything more than what he thought was required based on his experience and based on his hearing the evidence and assessing it, then it would be an inappropriate penalty because, as I mentioned before,
Mr. Garcia, your 5 minutes is up.
What about the 1 minute I reserved?
Well, if you can wrap it up very quickly.
Okay, that's it. Well, the whole notion is really not the factual findings. Yes, the factual findings are there. It's why the proposed disciplinary order was made, and you look at factual finding 32 to tell you why he deviated from those guidelines. And I think that a public letter of reprimand was the appropriate measure here. Thank you very much.
Thank you. All right, Ms. Lopez?
So I'll start where Mr. Garcia just left. Page 22, the proposed decision, paragraph 15. Judge Dash does not anywhere here mention why he's deviating from the disciplinary guidelines. And again, what Mr. Garcia and respondent failed to understand is this is a violation of the Business and Professions Code 2227, which says that a PLR may issue along with educational courses, but you can't have a practice restriction. Now, I want to make this very clear. I am not arguing that you should give him a PLR and medical record keeping. I want to make sure that that is clear. What I'm arguing is he needs a probationary order. The probationary order can just have the medical record keeping and the prohibition on recommending marijuana. It can be 3 years, 5 years. I'm not making a recommendation regarding that, but it needs to comply with the law. And 2227 is violated here, plain and simple. With that, I will submit it.
All right, thank you very much. Okay, did any members of the panel have any questions for our respondents' counsel or our, yes?
Mr. Garcia, is Dr. Shaham willing to answer any questions?
Yes, he is. Yes, he is.
Okay, Dr. Shaham, so you,
Maybe I'll put him under oath before we do
Yes,
that?
please, go.
Okay, all right. Dr. Shaham, would you stand and raise your hand? Raise your right hand. Do you solemnly swear or affirm under penalty of perjury that your testimony in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Okay, go ahead.
so Dr. Shaham, you don't need to answer the first question, but I do want to make sure that you can answer the second one. Now, my first one is, you had a busy OBGYN practice. Why did you get into marijuana recommendations? And second one is, are you willing to stay away from the rest of your practice career into marijuana recommendations or anything which we are not trained in our specialties? I'm a surgeon, you're an OBGYN, so we're trained certain way. We don't do liposuction, usually don't do marijuana recommendations, so that those are the two questions.
What were the two questions? To answer the second question is yes. I'd be willing to stay away from it. How did I get into it? I was in the process of retirement, actually 3 OBGYN doctors, and we set up first we covered another clinic that was giving marijuana recommendations. And then we started doing it ourselves. We gave marijuana recommendations, thousands of patients with a lot of experience. The physical exams were basically brief exams, which take a few minutes. Some of them took over 30 minutes, depending on what the situation was. If they had cancer or other issues, we spent more time. If they just complained of a sleep problem or muscle aches, and it improved their lives to get marijuana recommendations. It was perfectly okay to give them the marijuana recommendation, which was fine. Like the two people here, investigators, had muscles post-exercise, and they had plantar fasciitis, which even the expert witness says it's horrible. Their expert witness said it's horrible pain, he couldn't walk, and so on. So we spent a little bit more time. We also gave, or at least I gave.
I think it's gone beyond the scope of the question.
Yeah. Thank you. Did you have any other questions? Anyone else have any questions on the panel? No. All right, thank you.
I do have a
Yes.
question. Doctor, did you have a different way of examining patients in your medical marijuana practice than you did with your OBGYN practice? And did you have a different way of keeping records?
Yes and no. I mean, I don't do pelvic exam on the patients. I listen to the lungs, hearts, and check the belly for hepatomegaly, basically, or tenderness, for which I don't do it lying down. I don't need to do it lying down. Other than that, I don't think there is much difference as far as the medical records. I set up my own form, which check marks basically cover most of the findings, and that's it. The big issue for a long time there was a thyroid exam, whether it requires palpation or not, when they had no symptoms and there's no apparent swelling. I didn't go ahead and touch the thyroid, they made a big deal of it, and their expert.
So again, Dr. Shaham, I just want to make sure we don't exceed the scope of the evidence, so maybe just really pay attention to the question and limit your answer to
Okay,
that.
it was in the evidence. Basically, no. A physical exam here and here, it's basically the same except for the gender and so on. But basically, they get the same exam.
Was your OBGYN practice walk-in? Well, was the medical marijuana practice a walk-in practice?
Yes, it's
Okay,
actually
and
most.
was the OBGYN practice a walk-in practice?
Yes, it's a walk-in practice except for recurrent patients. I've had patients for 20-some years. They came in initially by walk-in, no advertising, almost no advertising here, basically no advertising. So I don't bring them in. I don't do 50 exams. It's about 20 exams maybe, and plenty of time to be more particular with a particular complaint. I treated it like in medical, where you have brief exams and comprehensive exams. Their expert witness said, oh, you have to put them on a table, you have to palpate this, and so on. And I treated it as what medical, the state medicals, for a brief exam, for a brief complaint.
Okay, thank you.
All right, any further questions from any members of the panel? Okay, then we will close the hearing at this time. Thank you very much. We're off the record.
Panel B. Are councils ready, or want a couple of minutes?
I'm ready.
I'd like to introduce Judge Jill Schlichtman.
Good morning, everyone. Let's go on the record before the Medical Board of California on the matter of the statement of issues against Hu Hua Victoria Van. This is Office of Administrative Hearings, case number 2015-07-1026, and board case number 800-2015-011627. Today's date is July 28, 2016. We are in South San Francisco, California for the hearing in this matter. My name is Jill Schlichtman. I'm the administrative law judge that's been assigned to preside over this matter by the Office of Administrative Hearings. I'll take the appearances of counsel for the record, please, starting with complainant's counsel.
Greg Chambers with the Attorney General's Office representing the Medical Board of California.
Thank you.
My name is Michael Firestone, and I'm representing Dr. Van, who's here on my left.
Thank you. All right, I think you are both aware, but I'll just reinforce that today's hearing is for the purpose of argument only, not the submission of new evidence. And Mr. Firestone, were you planning to have your client testify at all, or just your own argument?
She's here also to make a statement and
Okay.
answer any questions.
All right, so that will be within your first 15-minute allotment then, or?
That would be fine, or we could save it for the end.
Okay. All right. Well, I'll, as you know, you each get 15 minutes for your opening argument. And would you like me to let you know when you have 2 minutes left, or?
Sure, that'd be great.
Okay. All right. Then, Mr. Firestone, you can go ahead and give us your closing argument. Thank you.
Good morning, Your Honor, and good morning to the honorable members of the Medical Board. Thank you for giving Dr. Van this opportunity to speak with you about the board's non-adoption of the proposed decision. Initially, I will discuss why we're here and what must be decided today. I'll review a little bit about the background information and try to put into context, historically, the out-of-state conviction that Dr. Van had. I'll also try to argue why adopting the proposed decision is warranted in this case, based on the totality of the evidence that supports the fact that the existing terms adequately protect the public as they are written in the proposed decision. To that end, I will discuss how Dr. Van has been able to keep up with her medical knowledge, even though she's been out of practice for quite a while. And I'll describe her future plans and provide of her providing much-needed medical services to an underserved patient population. And then finally, Dr. Van will answer any of your questions and make a short statement. As you know, this case came before the Medical Board as a statement of issues based on Dr. Van's appeal of her denial of her medical license, based on an out-of-state conviction. There was a one-day hearing in January of this year in Los Angeles, and the ALJ drafted a proposed decision dated March 3rd, 2016, which granted Dr. Van her medical license with specific probationary terms and conditions for a period of 5 years. Beyond the standard terms and conditions, the proposed decision's order included the following requirements. She was to have a practice monitor. She was restricted from supervising physician assistants. She had to have additional education consisting of 40 hours per year of probation. She was required to have a prescribing practices course, medical record keeping course, and ethics and professionalism course. Dr. Van was then notified that the Medical Board had decided to non-adopt the proposed decision, and she was invited to present argument today related to the level of discipline imposed. Dr. Van and I are very hopeful that after today's presentation, the members of the board will have complete confidence that adopting the ALJ's decision as written is the correct and prudent course of action. We're hopeful that the board members will agree that the ALJ correctly found that Dr. Van has established her rehabilitation such that her relicensure would pose no danger to the public health, safety, and welfare, and that the totality of the evidence established that while a practice monitor would be appropriate condition of probation, the additional condition of completion of the PACE program is not warranted. I'd like to put some historical context into what occurred that got Dr. Van into trouble. You know, although California case law supports the notion that we're supposed to mostly focus into the Dr. Van's rehabilitation and character since her license in Mississippi was disciplined and surrendered, as well as a criminal conviction, and not on the events that happened before that time. But I think it's important for the board members to put into context the underlying conduct that occurred out of state, which will hopefully help explain why it is unlikely to reoccur in the future. The underlying conduct that led to Dr. Van's arrest involved a single misdemeanor offense for the distribution of a Schedule V controlled substance outside of the scope of professional practice. The charged conduct related to a single patient that Dr. Van treated in Biloxi, Mississippi, in the Gulf Coast in May of 2008. Backing up a little bit from the criminal conviction, it's important to understand what was going on during that period of time. Now, Dr. Van had a prior California license for many years. She was trained here, and she lived here for many years. But she moved to Biloxi, Mississippi in 2002 to join her husband's existing medical practice. Dr. Thomas True, at that time, was the only Vietnamese-speaking physician in the area. I personally didn't realize this fact until I was working with Dr. Van on this case, but apparently the Gulf Coast region is home to many Vietnamese Americans who immigrated there to work in the Gulf's shrimping industry and the seafood processing plants there. So it was not uncommon for patients to drive for many miles to go see her, long distances, and Dr. True. In 2004, they welcomed their first child, Jaden. In the summer of 2005, she learned that she was pregnant with her second child. And in August 2005 is when Hurricane Katrina hit that area. It was during that time that Dr. True's medical practice was devastated by Hurricane Katrina. And the damage to the Biloxi area was overwhelming. Overall, over 1,000 people died, and during the subsequent floods and the storm, making it one of the deadliest hurricanes in the United States since 1928. Total damage was estimated at $108 billion. Dr. True's medical office building was completely destroyed. Patient files were ruined, and like so many families in the region, they were displaced from their home. Despite pressure from their families to move away and move back to California, they chose to stay and try to rebuild. So they did their best to rebuild their medical practice and recognized an extreme need for medical care during that time. It's hard to imagine how much of the destruction of Hurricane Katrina changed the landscape of the Gulf Coast region. Not only the buildings and infrastructure, but the people were impacted severely, not only financially, but mentally and physically as well. The devastation led to many social problems and unique health problems. People were displaced, many were unemployed, and many had lost everything, including family members. This led to increased cases of post-traumatic stress disorder, anxiety, and depression, all at a time when the county mental health services were really hard to get. So this put a huge stress on primary care physicians to treat patients with mental health issues. There were also some unique physical disorders that popped up after Hurricane Katrina, such as respiratory disorders and skin disorders. These were a result of the mold and mildew and the debris that Hurricane Katrina caused. There was an increased number of respiratory complaints, or post-Katrina cough was what they called it. It was also caused by the formaldehyde that was in these trailers, the FEMA trailers that were placed for people that were displaced from their homes. So since so many physicians left the area and there was such an increased demand in medical care that was needed, this caused a huge influx of patients to their practice. The reason that I mention this is that it's a combination of all of these factors that gradually led to the increase in the number of patients coming to Dr. Van's husband's clinic. During this time, Dr. Van had her second child in February of 2006. and she drastically cut back her medical care that she offered at the clinic. She was only working there 1 or 2 afternoons a week, and as a result of the increased patient volume, Dr. True simply took on too many patients. So in the afternoons that Dr. Van did actually go to work at the clinic, she tried her best to help alleviate some of the patients that were building up in the waiting rooms, and oftentimes would treat patients that weren't typically her patients, but were patients that were her husband's patients, just to help so they weren't waiting so long. So that was the case for the patient that she ended up getting charged for the promethazine with codeine. She had seen this patient who was her husband's prior patient and essentially refilled the patient's prescription. She didn't do a very thorough physical exam and didn't recognize that the patient's condition was lingering, and maybe she should have sent the patient to have some additional diagnostic testing. She recognizes these and has admitted her mistakes, but these are the things that the board can be confident that would never reoccur, since Dr. Van has completed the board-approved remedial education courses in record keeping, prescribing practices, and ethics. Now keep in mind at this time, what we take for granted here in California, the Cures database system, was not available in Mississippi at that time. In addition, a lot of the patient's records that were simply just destroyed in the storm, so it made it very difficult for even the best of doctors to try to track down whether this patient had had other legitimate health conditions. So it wasn't until later that they realized, that Dr. Van realized, that many of the patients were exaggerating their health claims and were using that as an excuse to try to obtain controlled substances. I'm trying to make a long story as short as possible, and will do my best not to leave out any of the pertinent facts. But if I miss anything, if the board has any questions, I invite you to ask Dr. Van, and we can help clarify anything that's still lingering. So what ultimately happened is the authorities in Mississippi became concerned about the clinic's high volume of patients that were going there, the high volume of prescriptions, and attributing to lingering respiratory conditions and mental health needs. So they ultimately executed a search warrant and in 2008 and searched the house and searched the clinic. At that time, both Dr. Tran and Dr. True were asked to surrender their DEA privileges and medical licenses issued by the Mississippi State Medical Board. And in an effort to fully cooperate with the authorities, they agreed to surrender their DEA privileges and medical licenses that day. They weren't represented by an attorney at that time. Now, following their arrest and indictment, they both remained in custody away from their children for nearly 3 months until the judge finally posted bail, or granted bail. It was revealed after the government reviewed all of the medical records that they had taken that it was clear that Dr. Van had seen far fewer patients than Dr. True. So ultimately, the government was willing to settle with Dr. Van to plead guilty for just one misdemeanor count of distribution of a Schedule 5 controlled substance outside of the scope of professional practice. And it was Dr. Van's understanding that the government prosecutor was going to recommend probation to the judge. On the day of sentencing, however, the judge ignored the prosecution's recommendation for probation and ordered Dr. Van into immediate custody, and she was to serve 1 year term of confinement. She was not allowed to see her children or her family before being taken away, which was somewhat not expected. I think it would be hard for anyone to argue that Dr. Van hasn't paid a substantial debt to society for her conduct. Her sentence for a misdemeanor conviction took her away from her 2 young boys. She ultimately served 6 months in custody and was then able to transfer her sentence to a supervised living facility in Southern California. And she was released in October 2010.
And
Now
you have 2 minutes left.
It is the reasons why the board should adopt the proposed decision is that Dr. Van understands that it was her burden to prove that she was worthy of a medical license. She had a very high hill to climb, and she has done so, and has set an example for others. In fact, the evidence is overwhelming to prove that she was worthy of a medical license and has been fully rehabilitated. The ALJ who presided over the one-day hearing, who heard witness testimony, observed witness credibility, and considered all the evidence and arguments, was convinced that Dr. Van had met her burden of proving that she is rehabilitated and she was no longer a danger to the public. The ALJ drafted a thoughtful proposed decision and did a superb job of summarizing the relevant evidence. Now, I think the board members would agree that the most compelling and hopefully reassuring evidence of Dr. Van's professional competence is her current employer. Dr. No's steadfast willingness to hire Dr. Van as a physician in his primary care practice, if she were granted a license, is a good testament to her qualifications. He's basically had a 5.5-year job interview for her. He's seen her competence, and he's actually already testified credibly, that the judge found credibly, that she, if she was given her license, would be able to treat his own family members, not only his patients, but also his own family members, including his children. Dr. Van speaks excellent English as well as Vietnamese, and she would be serving an underserved patient population. She's fortunate to have a job waiting for her from a boss who values her work and commitment to medicine. Assuming that Dr. Van is granted a second chance and obtains a medical license, Dr. Van anticipates working for Dr. No in Southern California and treating the Vietnamese population in Orange County. She also intends to pursue her pediatric medicine reboard certification and then her internal board recertification. She had been previously double board certified.
All right, and your time is up. Thank you, Mr. Firestone. Mr. Chambers?
Thank you. At the hearing, and again today, what we heard was an attempt to minimize the actions of respondent in Mississippi. The judge scuppered the deal offered by the U.S. attorney because, as he said, quote, it was a criminal enterprise, close quote. This was not about a single patient. Not only did Dr. Van serve time, she was sentenced to 1 year plus 1 year probation. Her husband served time, and the pharmacist who was involved with them also served time. This is a group that was making money hand over fist, as was provided in the evidence, to the underserved in that community in the years subsequent to Hurricane Katrina. Dr. Van has not practiced medicine in the state of California for 14 years. Dr. Van has not practiced medicine at all for 8 years. It is the position of the medical board that, based upon the actions of Mississippi and the events that occurred during and after Hurricane Katrina, that the respondent has still not rehabilitated herself while she's come back to the state of California. If, however, the board, this panel, believes that she has rehabilitated herself, we note the ALJ's opinion fails to require a PACE assignment. With 8 years and 14 years of non-practice, there is no way the public safety can be certified by the medical board without a proper assessment of the skills that are currently possessed by the respondent. And with that, we would submit.
Okay, thank you. Mr. Firestone, would you like to, we have 5 additional minutes for your closing argument.
Okay, thank you.
Go ahead.
To the point of the counsel from the complainant has made regarding Dr. Van and her husband making money hand over fist, I think that's a misleading statement. The values that were quoted in complainant's written argument of making $600,000 1 year and $800,000 the next, I think is also misleading, because that was a gross amount. That was what the practice was making. That wasn't profit. That wasn't what they were taking home as profit. So I think that also needs to be taken into context. They had to pay their rent. They had to pay their employees. It wasn't profit. She's practiced in the setting has been very lucky to practice in a setting as an office manager of a very busy primary care clinic in Orange County for the last 5.5 years, where she's been submerged in medical knowledge and basically done everything involving medical care except actually providing the medical care. The treatments she's kept up with because she sees what the patients are being diagnosed with. She's familiar with the EMR system, the billing codes, the diagnoses. She's actually attended several conferences. She remains in her practice. Her boss, Dr. No, puts on a weekly radio show regarding medical issues, and she's the one that researches each week's medical content and topic. All these are all the new, hot topics of today. So she's familiar with today's cutting-edge treatments and medical issues. She's already taken an additional annual conference in April of this year after the hearing took place, and that was discussed in the respondent's written argument. The fact that she has the total support of Dr. No, her current employer, who's in the best position to assess her judgment and her medical competence, I think is the best evidence that the board can use that she is ready and capable. She's also demonstrated clear examples of the lessons that she's learned through this entire process and has tried to use it as an entire learning experience. She's also completed already the medical record keeping courses, the prescribing practice courses, and the ethics courses that the board uses to help remediate physicians who are undergoing discipline. She intends to treat an underserved patient community, and she has the support of her family and of her community. Disciplinary action is not intended to punish, but rather should be meted out with the goal of rehabilitation of the licensee.
And Mr. Firestone, let me just let you know that if you wanted to present testimony from your client, you need to do that within your allotted time. You can certainly offer her to answer questions of the board, but if you wanted to present testimony,
Okay.
you have 2 minutes left.
Okay, then she would like to present now.
Okay. All right. Can you first stand and raise your right hand to be sworn? Do you solemnly swear or affirm under penalty of perjury that your testimony in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. Thank you. Okay. Go ahead.
First of all, I'd just like to thank you, members of the board, just for giving me this opportunity to be here and to review my request. I'm here today because it's a result of my actions and the mistakes and my deficiency as a physician, what I did in the state of Mississippi. And because of it, I've jeopardized the trust of the medical profession, and I'd also failed to my duties to safeguard and protect patients who were entrusted under my care. I accept full responsibility for my action and for my inaction as well, and also for my poor judgment, as I did not do enough to stop or prevent potential for misuse or abuse in these cases. I understand the concerns of the medical board because of the serious mistake and the nature that I was involved in, and at a great price, I had learned many valuable lessons, especially to be stronger in my character as a person, to say no, to speak up and not give in to the demands of patients or others. I learned that I needed to be responsible for the evaluation of each and every patient I saw, even though I may be cross-covering for them. And then I learned that I need to utilize other resources available by referring them for testing or referrals to specialists. And although I may have respect for the physician I work with, but I need to question them and also to see area of concern in the management and document and take corrective action. During my confinement, I immersed myself in self-evaluation and learning, although they could not rectify what happened. but I wanted to be a
And
better and a
I'm sorry,
responsible
but-
person.
We're out of time, but thank you. The board members may have some questions for you afterwards, all right?
Sure.
Okay, Mr. Chambers, did you have any additional comments?
Just finally, with regard to the education that was presented just moments ago, we cannot, the community at large, and the medical board, which has a duty for the public safety, cannot accept a self-assessment with regard to the knowledge and skills of the respondent. And until there is a full evaluations of the skills and knowledge of the respondent, it would be inappropriate to offer probationary license unless and until that PACE requirement is added and fulfilled as a condition precedent. Thank you.
All right, thank you very much. Okay, at this time, do the members of the panel have a question? Yes.
Thank you, Judge. Dr. Van, I saw that your one count you accepted in Mississippi was a Schedule 5 drug, which is an antihistamine. But did you ever get calls from either the hospital emergency room or the coroner's office that your patients overdosed anytime during that practice? I don't have that information.
No, I did not have any patient whom I saw or prescribed that overdose that I was involved with in the care, no. This patient was a patient who was non-compliant and was a smoker, and I saw the patient as a coverage and refilled the medication. I was not made aware of what some of these patients were doing until later on, when I was made aware, because it was a cough prescription, that I drastically decreased the prescription and changed my prescribing habit.
All right, do any other panel members have another question? Any other question? Yes.
I do. I would just like to hear more about, from respondents' view, more about the PACE, the requirement to take on the PACE courses, and what's your view, doctor, on that, and would that not be helpful for you?
Yeah. I would be willing to do what the board deem necessary to say that I'm safe and to practice. But I realize I have not been in practice for a long time, so that's why I started attending live CME courses. And since 2004 until now, I have accumulated 127 hours of attendance to the CME courses. And those including the prescribing courses, medical ethics, and medical record keeping. The office where I'm working allowed me the opportunity to work with patients, providers, other hospital healthcare services such as hospital, pharmacies, and insurance plans, where I get a lot of calls regarding medication clarification, lab orders, or results that were viewed by physicians, and even to submit, to review notes for audits, for quality measure reporting, or preventative screening measures. So I'm immersed daily in the care, in reviewing the records, the doctor notes, reviewing labs and prescription. So that helped me to be able to be in the medical environment and to keep up. And Dr. Ngo always, he's an ongoing learner, challenges me with little projects and looking up things like what should we do in this case, in this patient with an abnormal lab or an abnormal pap smear or has positive HPV. So what do we do in this, Victoria? And he would have me look things up or find the protocol for this. And so those are the things I do at the office with him for the past 5.5 years. In regard to the PACE evaluation, I learned that it's a 7 days program, 2-phase, and I was quoted the cost would be about $16,000 to $19,000 for the program. So for me, financially, it's cost prohibitive. And I just would like the board to respectfully look for other alternatives. Should I do more CME courses or classes as alternative to the PACE requirement?
Okay, any other questions? I don't hear any, so thank you, everyone. We're going to close the hearing at this time. We're off the record.
Okay, good afternoon. I would like to welcome you to the Enforcement Committee session of the Medical Board of California. Today is July 28, 2016, and the time is 13:25, I believe. I'm Dr. Felix Yip, Chair of the committee. I would like to ask all of us to please turn our cell phones to silent. And for the board members, please make sure that are off the table so we can avoid the feedback noise. You may notice board members accessing the laptops during the meeting. They are using the laptop solely to access the board meetings material that are in electronic format. This is an official business meeting of the Medical Board of California, and as such, disruption of the board's business will not be tolerated. We have a designated time on the agenda for public comment, and we will be asking for public comment on each agenda item. I ask that you be respectful of the need to conduct the board's business. Should anyone disrupt the meeting, I also ask the person to conduct himself or herself in such a manner that permits the board to transact the business. The board welcomes public comment on any item on the agenda, and it is the board's intent to ask for public comment prior to the board taking action on any agenda item. If for some reason I forget to ask for public comment on an agenda item and you wish to speak on that item, please raise your hand or come forward and you'll be recognized. I would like to request all speakers complete a presenter slip so I can call you by name at the appropriate time, and the record of this meeting can be full and complete. However, this is voluntary. Please give the speaker slips to Ms. Toof. Ms. Toof, can you identify yourself for the audience? Thank you. This meeting will be available via teleconference. Individuals listening to the meeting will have an opportunity to provide public comment and will be assisted by a moderator who will be facilitating the teleconferencing process. For those members of the public participating via the telephone conference, please wait until the moderator has introduced you before you make your comments. To request to make a comment during the public comment period, press star 1. You will hear a tone indicating you are in queue for comment. If you change your mind and do not want to make a comment, please press the pound sign. Please remember to mute the volume on your screen to avoid the feedback. Assistance available throughout the teleconference meeting. To request a specialist, please press star 0. Each person will be limited to 3 minutes per agenda items. However, during agenda item 2, for public comments on items not on the agenda, the board has limited the public comment period for individuals on the teleconference and those present here today for 20 minutes. Therefore, after 20 minutes, no further comment will be accepted. During public comment on any other agenda item, 10 minutes will be allowed for comments from individuals on the teleconference line and those in the audience. After 10 minutes, no further comment will be accepted. Staff from the board's business service office will be assisting me with receiving the public comments via telephone conference during this meeting. I want to remind all speakers to please stay on topic and keep your comment to 3 minutes or less. I would like to call this meeting to order and have Ms. To please call the roll.
Dr. Yip?
Here.
Dr. Bolat?
Here.
Dr. Kraus? Present. Thank you.
Thank you, we're quorum, and would like to remind the member that we will be taking a roll call vote on all action items. And also for the public, after today, we should have more public member on our committee. Moving agenda item 2, public comment on items not on the agenda. I have the following speaker slips, and Tay Morse. Mr. Morse.
Yes,
Sorry, I have to find out if you're a gentleman that said Mr. Morse.
it's okay. Can you hear me? Okay, good. My name is Ty Moss. I am here on behalf of the Consumers Union Safe Patient Project, a nationwide campaign that is organizing patient safety advocates from across California as a safe patient network. The Medical Board Executive Director has assigned the Enforcement Committee to look into amending the Medical Board disciplinary guidelines regarding to patient disclosure of probation status. We urge the committee to recommend that the board disciplinary guidelines be amended to require that physicians on probation for serious issues inform their patients of their probationary status. Unfortunately, many California patients unknowingly receive health services from physicians who have been placed on probation for a range of offenses, including substance abuse, sexual misconduct, violence, patient deaths, incompetence, gross negligence, and repeated negligent acts. When the medical board allows the physicians to continue practicing medicine while on probation, the physicians should notify their patients so they can be aware of any practice limitations and can decide for themselves whether or not they want to entrust their care to that physician. Medical board guidelines require that physicians to notify hospitals where they have privileges and their medical malpractice insurers. Certainly, patients also have the right to know when their physicians have been seriously sanctioned by the medical board. According to published research and the medical board's own data, physicians on probation are much more likely to require further discipline than physicians who've never been disciplined. We also recommend that patient notification requirements for physicians who are ordered on probation more than one time. We recommend that the medical board demonstrate its commitment to patient safety by amending its disciplinary guidelines to require, as a standard condition, physicians whose probation is associated with certain serious violations and practice restrictions be required to disclose their probationary and practice restrictions to their patients. In addition, to help people understand why physicians have been placed on probation, to fulfill the medical board's principle that all consumers should know the history of probationary actions, the medical board should develop a standard one-paragraph, plain language summary that the probation ordered. The summary should cover the cause of the probation, including the accusations to
Please
those
conclude.
which the physician stipulate, the length of the probation, and all practices restrictions placed on the physician. The summary should include, in the first section of the decision and order of probation, in plain view of the physician's Breeze profile and website.
Mr. Moss,
Yes.
please conclude.
I will do. On the medical, we also ask that the medical board should also amend the disciplinary guidelines to wit the patient notification and optional conditions on all probation cases. This notification should include the log that we have just recommended. The medical board should develop an effective process to ensure the enforcement of the disclosed requirements. Thank you.
Thank you. I only have one speaker lip, no more, okay. Are there any comments on the phone?
Greg, do we have any comments on the line?
We have no questions in queue at this time.
Okay, thank you. So we move on, next agenda item.
Move approval of the minutes.
Second.
Okay, great. All right, are there any public comments from those in the audience? Any comments from those on the phone?
Do we have any comments on the line?
We have no comments from the phone lines.
Thanks. Ms. Tu, please call the roll.
Dr. Bolat?
Yes, approve.
Dr. Kraus? Aye. And Dr. Yip?
Yes.
Thank you.
Minutes approved. We now move on agenda item 7. Ms. Delp will provide an enforcement pool update. Ms. Delp is our Chief of Enforcement.
Good afternoon. So the board has tentatively scheduled its next 2 expert reviewer training events. The training events are scheduled to be held on October 8th at UC San Francisco and on November 5th at UC Los Angeles. A save-the-date announcement was already mailed to all existing experts within the program, and staff is working with the board's Information Services branch to develop an online registration feature that will make it easier to handle this part of setting up the training. The agenda for the training will stay the same, focusing on the expert program's mission and expectations, legal considerations when opining on a case, a rundown of different case scenarios, and segments on testifying provided by an administrative law judge, a deputy attorney general, and a defense counsel. But the training will now also include a segment providing an overview of the board's central complaint unit's handling of the complaint process. And also the summer newsletter has an article about the training, which was conducted in March, so the board hopes this article will also help spark interest to entice physicians and surgeons to attend the training sessions. Training with the Office of Administrative Hearing will resume this fall, and training will be held in September, October, and November. The judges will be educated on emergency room procedures, comorbid patients, and fitness for duty evaluations. At the conclusion of the November training, the board will have provided 6 training sessions to the Office of Administrative Hearings, fulfilling its strategic objective to provide training to the administrative law judges. In 2017, a needs assessment will be conducted to determine what other topics of interest the judges may be interested in receiving training, and based on that assessment, further training may be developed. The Central Complaint Unit has decreased the average number of days to process a complaint from 162 days to 146 days. Staff has been working very hard to reduce this time frame by working overtime. Management in the Central Complaint Unit continues to evaluate the way business is conducted to find ways to streamline the process. By identifying more ways to be efficient, the processing time frame will continue to decrease. At a future meeting, Enforcement Program Manager Paulette Romero will provide the committee with a presentation on the Central Complaint Unit's complaint handling process. The Complaint Investigation Office continues to be able to maintain a caseload of approximately 55 cases per each non-sworn investigator. Management's also evaluating the timeframes it takes for CIO to process its workloads and may make some changes, including shifting some less complex duties to support staff, which will permit the investigators to focus on interviewing witnesses and subjects, initiating subpoenas to obtain medical records, and report writing. The Attorney General's office continues to report that the work product produced by CIO is excellent, and I personally want to say thank you to staff for their outstanding efforts. In the probation unit, management continues to review office policies and procedures to ensure optimal efficiency of this unit. With the changes being made in the unit, I also want to publicly say how much I appreciate staff's supportive attitude to the changes. As we all know, change is often a difficult adjustment. We're working diligently as a team, and improvements are paying off as the unit has increased the number of cease practice orders and petitions to revoke probation cases being transmitted to the Attorney General's office during fiscal year 15-16 compared to 14-15. Later during this committee meeting, I also provided a presentation regarding the timeframe objectives for staff to take action on violations of probation. With the exception of the Complaint Investigation Office, there are 6 vacant positions within the various sections of the enforcement program. Efforts to fill the vacancies continue. Some interviews have been conducted and others have been scheduled, and tentative job offers have been made pending the results of background clearances. It is anticipated vacancies will be filled by no later than September 30th, and the vacancies have not created any significant adverse impact to the workloads. That concludes my enforcement update.
Any questions, comments from the members? Any public comments from those in the audience? Any comments from those on the phone?
Do we have any comments on the line?
We have no comments from the phone lines.
Thank you. Move to agenda item 5. Ms. Robinson will now provide an update on the demographic study.
Good afternoon, Chair and members. I provided an update on the demographic study at the January Enforcement Committee meeting. It was reported that the next step would be for the California Research Bureau to finalize the research design and methodology, then provide this information to Dr. Kraus for review and approval as approved by the board when requesting this report. I did not provide a verbal update at the May meeting, but a written update was provided in the enforcement program summary. It stated that on April 18th, Dr. Kraus and also Dr. Baker with the Black American Political Association of California and the Golden State Medical Society received the research plan for review. It was further stated that once Dr. Kraus approved the plan, it is expected to take approximately 2 months for the analysis and an additional 2 months to finalize the report. Dr. Kraus has approved the plan, and the plan is near completion. As a reminder, the California Research Bureau provides nonpartisan research services to the governor and his staff, to both houses of the legislature, and to other elected state officials free of charge. So the board has not incurred any costs to conduct this study. Executive Director Kimberly Kirkmeyer and I met with Patrick 2 weeks ago to discuss his progress. Patrick is a senior policy analyst at the California Research Bureau who has conducted the study. From that meeting, it is Kim and I's expectation that Patrick will be ready to present this study findings at our October board meeting. This concludes my update on the demographic study.
Thank you, Ms. Robinson. Dr. Kraus, any comments? Since you're in-
No, I think this is a vitally important study. Thank you. I think this is a vitally important study. And I'm hoping that upon receipt of their report, there will also be able to develop some mechanisms for ongoing analysis on a prospective basis. Because unless we remain on guard to any potential prejudice in the board actions, we can never guarantee that there won't be any. Thank you for your work on this.
Yeah, you're welcome.
So we should see something in October, right?
Yep.
Thank you.
Thanks.
Any public comments from those in the audience? Any comments from those on the phones?
Do we have any comments on the line?
Yes, we do. We turn to the line of Dr. Anthony Jackson. Please go ahead. Your line is open.
Yeah, hi. Hello, Medical Board of California, Dr. Jackson. I apologize. I couldn't be there. Hello?
Hello, we're listening.
Yeah, Ms. Robinson, first of all, I want to thank you and Executive Director, Ms. Kimberly Kirschmeyer, for proceeding with this very, very important study. And I just want to let you all know how much we appreciate your guidance and your moving forward with this important agenda. I apologize. I had hoped to be there in person, but I missed my flight. So, but anyway, again, I thank the medical board and everybody, and please keep us updated on this very, very important study. Thank you.
Thanks. So now move on. Agenda item 6, Ms. Delp will now provide a presentation on the expert review program's recruitment plan.
Hello again. Okay, so I'm going to do a brief presentation on the expert reviewer recruitment plan that the analyst and myself in the program have put together. So first going to start with what is our current recruitment efforts. And what it exists of is we put an announcement in our medical board newsletter. In every newsletter, we put a standard recruitment verbiage, and it includes the medical specialties that the board is actively looking to recruit. So you probably have seen, oh, that's the end of my presentation. No, I'm just kidding. What'd I do? Okay, there you go. Making sure everybody's awake. So, you've probably seen this in the newsletter. Did we just put the medical specialties that we are needing further assistance in it in the newsletter, and it's just been our standard language. Other areas where we recruit is just by the use of our medical website, medical expert website. And there's 4 locations where you would find information about the expert reviewer program. But finding that information is not as easy. You have to either go up to the search engine up here and actually type in the expert reviewer program. You also have, under the licensee tab, then you also then need to click further into that area, and you need to go click on like the physician and surgeon link, and then at the bottom of that page, you'll find information about the expert reviewer program. You can also go to the About Us tab, and then you go to the Careers tab, and link underneath that, and then you also have to go further to find out information about the program. And then lastly, you can search through the alphabetical search link and type in expert reviewer program. So the problem with that is you can see the layout that the information is embedded, and it's just not easily for people to find information to become an expert. And lastly, our other recruitment efforts are through our board's medical consultants and our current experts. You know, they both encourage colleagues to become experts. And as you can see, not much activity nor exciting ways to entice the physicians and surgeons to join the program is currently how we utilize that information. So we put together this recruitment plan, and we hope that by doing that, we can bring more individuals into the program, and our plan consists of 3 stages. So in stage 1, which we hope to complete by fall of 2016, we've added a new link to the home page, and that's already completed. So now when you go to the home page of the medical board website, there's actually this nice picture, and it has a slogan on it, and you can click on that, and it'll take you right to the expert reviewer page. So it's just right on the front page of the web. We've also added the graphic and the tagline, and our goal is to change the graphic and the pictures maybe biannually to just keep it fresh and keep it exciting and not just keep using the same picture over. We've also enhanced the licensee tab. Now it goes directly into the expert reviewer program information, and we're also going to begin to track some analytics. We'll be able to embed into these links where people are actually searching for this information and to see what value and benefit we get from making these improvements. Okay. My notes. Also, we're going to enhance our newsletter. We're going to continue to advertise as we normally do on a quarterly basis, but we'll enhance the announcement by including quotes from current experts that speak as to why he or she became an expert, their experiences, and the benefits about being in the program. And then our goal, again, is to help entice more physicians and surgeons hearing directly from their peers that they'll be more inclined to participate. We're also going to possibly include some photos of these experts and then some catching quotes as to why they are participating in the program. We're also going to solicit current experts to write articles for our newsletter, talking about their experiences and maybe to gain some more participation. And then again, even on the links on the net, there'll be some embedded links into our newsletter that we can track some analytics as to how people are finding the information. And then lastly, in our first stage, we're going to get an invitation letter drafted hopefully by the board president. And this letter will encourage participation into the program, talking about the benefits and the importance of the program. And our plan is to send this letter to department heads at medical schools to recruit faculty to become experts. And the letter also, we hope to be sent out with our license renewal applications when people meet the qualifications and they want to reapply for their medical license. We also are going to create a brochure, and this is just a sample, so it's not finalized yet. This document will provide important highlights about the program to include the roles of the experts, requirements to become an expert, and the compensation information. The goal is to use this brochure at recruitment conferences. We'll mail them to physician surgeons that also have renewed their board license, and we'll ask specialty associations to distribute it to their members. So then, stage 2, which we hope to complete by spring of 2017, we're going to enhance our medical board newsletter. And this is a sample of an old but fun approach to recruit experts. It was something that was done actually 21 years ago in 1995, and it's taking an applicable a quote, and turning it into a marketing advertisement. So we're going to be brainstorming and trying to come up with some new ways to entice people to join. So if anybody has any quotes they'd like us to turn into some great advertisement, we're looking for help with that. Also, we're going to be researching external newsletters and magazines with medical specialties associations, specialty boards, and seeing if we can put like an advertisement, just a simple, just a little ad about the program. And of course, we're going to have to, explore the cost associated with this, but that's our intention also, is to just do some spot ads. And then staff will begin to attend hospital staff meetings, board CME activities, and special conferences. And there at those presentations, they'll be giving out materials like the brochure that we're going to draft, and also the president's letter to those that attend. And then stage 3 of our recruitment plan we complete in the fall of 2017 is to add to our website, our medical board web page, is to create some short snippet, like 1 to 3 videos. The videos are going to be like a little small public service announcement encouraging participation into the program. So we would like to have perhaps like the board president, our executive officer, Kim Kirchmeier, myself, some current experts, maybe our investigators, and some deputy attorney general, just kind of getting a little snippet of a video and interchanging that periodically throughout too, just to keep it fresh. So that's pretty much what's it. If any comments or suggestions?
Thanks, Chief. I know the committee, the division has been working to put one day in October, one in November. UCLA, UC San Francisco, and also USC in Los Angeles also agreed to work on some days in the spring to help recruit experts, particularly from the faculty. They have more than 1,000 faculty that can send out invitation. So thanks for effort. Any comment from the members? Are there any public comments from those in the audience?
Do we have any comments on the line?
Yes, we do. We turn to the line of Genevieve Clarewell. Please go ahead. Your line is open.
Yes, on the recruitment project, it seemed very well done, and I'm very excited that you're going to do that. I think it might open some road to good recruitment and retention. And one aspect I think we need to be added also is civility, how we impact also the recruitment and so on. So thank you for doing that. That's all I have to say.
Thank you.
Thank you.
Okay, we'll move on to agenda item 7. Mr. Chris and Ms. Nichols from the Health Quality Investigation Unit will provide a program update on vertical enforcement.
We will be providing an update on the division's Health Quality Investigations Unit. At the last meeting, we reported that we've been conducting expeditious hiring panels throughout the state and had made improvements to streamline the background process and make it more efficient. However, it is difficult to overcome the amount of time needed to hire sworn peace officers due to the psychological screening and medical portion of this process. Once that is completed, if the candidate needs an academy, it can take another 6 months before they can assist with the caseload. Currently, we have 27 investigator vacancies. a 35% vacancy rate, and we have 14 investigator candidates in background for the investigator positions. Decreased staffing affects timelines for case completion. With the vacancies, caseloads have risen for the existing investigators. In many areas of the state, the caseloads are at 40-plus cases per investigator. Because of this, we have taken proactive, strong mitigating steps to deal with the increased workload. Effective July 1st, 2016, all new Board of Psychology and Osteopathic Medical Board cases will be investigated by the Investigation and Enforcement Unit of the Division of Investigation. They will continue to receive cases from these two allied health boards on a temporary basis until HQIU staffing levels return to normal. In addition, 61 existing cases from these boards were transferred to IEU from HQIU to help alleviate the rising caseloads. We are also hiring 8 limited-term, non-sworn special investigator positions that will be housed at the San Bernardino field office. These positions can be hired without the delays of background and academy process and can provide immediate relief for working the lower priority cases. These positions are not permanent, but a good placeholder to obtain some immediate relief to complete cases while the sworn candidates are in background. We plan to conduct interviews mid-August to select candidates for these positions. Additionally, we are also hiring 2 limited-term special investigator assistant positions in the Sacramento and Pleasant Hill field offices. This pilot program, if successful, will give us the ability to gather the necessary data to justify budget change proposals for new funding to permanently fill these important positions. As you know, pay has been a significant factor causing investigators to leave the agency. As we reported in the past 2 meetings, retention pay was pending the collective bargaining process. The new contract ratified by Bargaining Unit 7 members in late June 2016 includes a provision that transfers the decision-making authority to issue retention pay to the department and to CalHR. Based on this new provision, we aggressively put forward a retention pay proposal for HQIU investigators to CalHR and will work with CalHR through this process. We will update the board with any developments on this vital issue. In February 2016, staff participated in a survey regarding vertical enforcement. One of the areas identified as needing modification was the subject interview phase of the investigation. We've been working with the Attorney General's office and DCA executive staff to make improvements in this area, and we will continue collaborative efforts to streamline the process. We are currently working on another joint training session with the Attorney General's office regarding subject interviews. Our last joint training, which took place in May of 2016 regarding 805 investigations, was very successful, and we look forward to building on this success with another valuable joint training session to be held later this year. Our investigators have persevered with the challenges of an increased caseload due to current vacancies. I commend all of our staff for the hard work and dedication they give every day to protect consumers, and I am confident that these solutions we have shared today will help HQIU and maintain our ability to perform core functions while staff progress through the background process. Thank you.
Thank you.
Any questions? Yes.
Thank you for working extra hard and overtime for us.
You bet.
Do you presently have candidates training in Academy that will be available soon, or?
Yeah, yes, we do. I can let Kathleen answer that.
We have one candidate that's currently in the academy, and then we have another candidate that's been hired, and she'll start an academy in October. They start at different times throughout the year.
And some of the 14 people that we have in background are actually have academies in their previous law enforcement experience. So some of those will be able to come on board right away.
Mm-hmm. And I know all too often you might not look forward to these meetings because we look at the graphs going up and we place blame on you. But we're not looking to assign blame, we're looking to help you solve the problem. Are there any suggestions you can offer to us in terms of better ways that we can advocate for you or for increased pay for investigators?
I think you have, and we've done a lot of work with the DCA executive staff, with the board, and I think some of that message came through loud and clear in the collective bargaining process. And, that actually, I think some of those comments that we've made and the support that has been given, regarding this issue has actually, surfaced in the collective bargaining issue, and the contract has been updated. So, that was a roadblock that I think that we've gotten beyond, and so I'm very optimistic, and look forward to hopefully reporting good news on this issue. But I appreciate everything that's been done so far. The board's been supportive. Board staff has been supportive. The department's been supportive, and I think we're taking aggressive steps to get beyond this problem. We're working with the Attorney General's office to streamline, and I think we're on the road to better days.
Thank you.
Thank you. Just a follow-up question to these graphs again, the 365 and the 550. Based upon your best estimates as a director and looking at your new plans and hiring FTE, when we hear about this in October, do you have a goal, an internal goal that we're going to decrease by some percent? What are you thinking?
Well, I think to answer that, the increased vacancies do, affect the timelines. And so we are in a spot now where there's new staff that are coming on board. It's going to take some time to get those people trained. I hope to report that the timelines will improve or at least stabilize by the next meeting. We will definitely have more staff on board. But, I think it's going to probably take a little time beyond that to start seeing the decreases, because I think we've made some progress, and we've got the ship steered in the right direction, but it's going to take some hard work to get those new people trained, to redistribute some of those caseloads, and to start seeing the graphs go in the other direction. I'm optimistic, but they will do so, and I think we're on our way to solving the vacancy issues.
I also wanted to add that part with the increased caseloads and decreased staff, we've really been focusing on prioritization and focusing on those cases that are the most egregious to protect the public. As a result of our significant efforts in that regard, some of the lower priority cases are aging a lot more. So sometimes in those graphs are hidden some of the lower priority cases. And I'd like to point out that we have made very significant improvements in the important area of ISOs, the interim suspension orders. There were 14 in the year 2014-15. There were 36 ISOs for year 15-16, which was over 100% improvement. And there was also a decrease in the length of time to obtain an ISO by 150 days. So we continue to prioritize and focus our effort and time on the most egregious cases. So sometimes that impacts the aging graphs.
One more comment, and I think you said that really beautifully, and I'm almost wondering if what you're saying could be depicted, because what you're doing at the front end is triaging, and when we would see that these are the most egregious cases that were coming down or something, so that you would almost sort it out in a little bit different than just an aggregate, that might be a nice visual to show us.
We'll check into the capability Breeze has to run those different reports, definitely.
Thank you.
We appreciate your effort, for sure. Thank you. Thank you. Are there any public comments from those in the audience? Any comments from those on the phone?
Do we have any comments on the line?
Thank you. Ladies and gentlemen, for our questions, please press star one. Not at this time.
We have no comments on the line.
Okay, great. Let's move on to agenda item 8. Ms. Castro, for Attorney General's Office regarding health quality enforcement section, will provide program update on vertical enforcement.
Good afternoon. As always, it's an honor to address you. In the past 3 fiscal years, since the time that the HQIU unit was set up in DCA, HQE staff in the Attorney General's office has vertically enforced on average about 1,500 investigations per year through our lead prosecutors and primary DAGs assigned to the office where the investigation is based. Our 40 HQE DAGs spend an average of 6 hours at $170 an hour, or just $1,200 a case per investigation worked in per fiscal year, in important legal tasks such as subpoena review, subject interview participation, expert review, case disposition review, and ongoing advice and consultation. In the selected cases that necessitate a personal appearance at a physician interview, our DAGs travel to the district office to service that case. Most legal direction from our staff comes from email communication and telephone conversations with investigators. And from time to time, travel is required by our staff to enforce subpoenas in civil court or attend criminal bail hearings. Throughout this entire direction provided in the investigation, the focus at the investigation stage is on the case at hand and the patients who trusted you, the medical board, with their complaint. The focus is on achieving public protection and in securing the best evidence to evaluate the patient care rendered. Our 10 lead prosecutors serve as in-house legal resources to medical consultants and investigators on all cases located in the office that they serve. Our lead prosecutors travel to these offices weekly and interact with investigative staff and monitor and account for all investigations in that office. The lead prosecutors identify statutes of limitation, conflicts, and triage high-priority cases. They work hard to manage a very large investigative caseload along with their own litigation caseload back at the office, which can include federal cases as well as training and advice to investigators. Our lead prosecutors take on assignments of petitions for mental examination, preservation of ceased practice orders, and reacting in quick order to enjoin physicians from hurting patients, such as in the interim suspension orders. They act as resources to DAGs assigned to investigations in that office. During this whole time, the Attorney General's legal staff directs investigations assigned to them. They manage a full litigation caseload that is in all stages of filing, settlement, hearing, post-hearing, writs, appeals, along with a long list of other legal tasks that may include appearing at reinstatement and probation termination hearings, statement of issues, citation and fine, and lawsuits, sometimes defending board members. Our DAGs work very long and hard hours. Their work week is not a 40-hour work week. They have to work as long as the time that it takes to complete the job. Health Quality Enforcement section at the Attorney General's office, we bill you by the hour and tell you what work we performed and the narratives attached to those bills. We do not receive a cost-neutral yearly amount from you. In other words, we don't get a lump sum to spend as we see fit. Every fiscal year, we return any unexpended legal service funds to you, the medical board. Of HQE's total legal services fund, investigations comprise about 20% of our total legal billings to you. In the last 3 fiscal years, the cost of the VE program in investigations for Attorney General services has been an average about $2.5 million per fiscal year. And that means an average of about 6 hours per investigation per fiscal year is what we spend working on your cases in a very judicious manner. This small investment has paid dividends in public protection, both in administrative disciplinary actions in which we file very strong accusations, obtain surrenders, revocations, interim suspension orders. We enforce your subpoenas when doctors don't want to give us medical records, and we create thoughtful settlements that rehabilitate and correct physicians and achieve public protection and public safety. My legal staff also identify physicians whose completed investigations should not be referred to our office for prosecution, and per outside independent expert review are safe to practice. The almost non-existent numbers of dismissals after hearing or withdrawals of filed accusations reflect the quality of investigations under the vertical enforcement program. Vertical enforcement protects good physicians by removing them from the cloud of suspicion in the investigation and also eliminating any unfounded accusations against them, such as withdrawals and dismissals. The in-house medical consultants play a major and key role in investigations by managing the lion's share of subject interviews. These are the interviews of physicians. It's a face-to-face contact, doctor to doctor, peer to peer. These medical consultants question the quality of care case and also identify the physicians who do not need to be remediated after a full medical consultant review. Often, medical consultants are the ones that recommend sending out cases for independent expert review, and our Attorney General staff is involved in identifying cases that might merit a citation and fine or a pre-accusation PLR, which is short of filing an accusation but sometimes addresses the issue. Educational letters are also sent out with medical consultant help. The vertical enforcement program has increased the quality of evidence reviewed by medical consultants and your retained independent experts. Namely, our participation in those physician interviews can take the form of submitted questions to the investigator or, as necessary, physical presence in physician interviews. This ensures, in our eyes as lawyers, that the accused physician has a clean presentation in transcripts and in those physician interviews of their thought process and the facts in the patient case. We take this very seriously. Sometimes following the explanation by the physician at this important interview, investigations are closed based on the medical consultant's review. And that can only be achieved if we have a very clear explanation that is thoughtful and that allows the physician to explain his state of mind at the time the patient care was rendered. At the same time, vertical enforcement has increased the quality of evidence needed to allow legal staff to identify whether or not the AG can meet our filing standards, which are based both on prosecutorial ethics and the burden of proof, which is clear and convincing to a reasonable certainty, which is second only to the criminal burden of proof of beyond a reasonable doubt. Your filing standards and our burden of proof is one of the highest in the entire country for medical board licensees. The quality of the evidence is not only scrutinized by the accused physician and their legal representative, but also the administrative law judge who review your cases for you at settlement and at hearing. And that same evidence that's collected during investigations is obviously perused very, very closely by opposing experts at hearing, and often by Superior Court judges on judicial review, appellate court judges on appellate review, and where applicable, the Supreme Court. Our talented Attorney General staff are sometimes outnumbered by multiple opposing counsel with more resources, and oftentimes multiple handsomely paid defense experts, sometimes one per patient or subject if that is what the ALJ feels justice requires for this physician who's defending his or her livelihood. Yet the quality of the obtained evidence and the opinion of our retained experts is what wins cases. The collection of evidence at the investigatory phase is what achieves discipline, and it all begins in the vertically enforced investigation. But that same evidence evolves at the litigation phase, which is where it's really put to its use. So the investigations are not an end to themselves. Investigations are bigger than the tasks performed by investigators. Each case involves a patient and the care provided to them, and it obviously involves the investigated physician. And it involves, most importantly, protecting future patients. DCA and their investigators only see the tip of the iceberg when they deliver a completed investigation to our office. The bulk of our legal work on your behalf occurs on filed administrative cases. Our DAGs live with the file case long after the investigation is accepted for prosecution and filing by my office. We take very, very seriously what we affix you, our client's name to, and what we present underneath Kamala Harris's name, the Attorney General. We live with these file cases until it is settled, defaulted, or heard by a judge, and we come here before you every quarter to explain our stipulation recommendations and appear at non-adoptions of proposed orders by ALJs. Our DAGs put their heart and soul, long hours of personal sacrifice to themselves and their families into every single case, as it represents in our eyes a physician to be revoked or remediated as dictated by the patient care or conduct at issue, care that did not meet your high standards. We know that the vertical enforcement program has resulted in stronger disciplinary outcomes especially in the identification of physicians exposing a danger to patients meriting an interim suspension order action, and including actions against physicians with mental or physical impairment, and in other public safety cases. At the same time, our legal involvement reduces cases against physicians who should not be prosecuted. And we feel that this is important. Physicians are part of the public too. HQE and my staff knows and appreciates that the vertical enforcement program exists solely to protect the public. It does not exist for any other reason. The deputies that work in HQE have weathered all of the challenges presented in the past 11 years by never losing sight of what the law intends. Our DAGs are extremely hardworking in an office where all of our deputies get paid exactly the same amount of money. Yet the DAGs in the other section, the deputies in other sections in our office, may not have as much legal work and may not have the same types of challenges that our health quality enforcement deputies have. Our deputies stay in the health quality enforcement section because they believe in the important mission to protect patients and to enforce the health quality in California. It's in our name, even if it means more work for the same pay. We have staff as well that took very hefty pay cuts to work here in HQE, and they come from the finest law firms and prosecutorial agencies all around the country, and I'm very privileged to lead such fine prosecutors. HQE agrees with the mission and intent of the legislation establishing the vertical enforcement program. Notwithstanding the challenges when the program was not really implemented as envisioned and the subsequent fragmentation caused by when the board lost its investigators 3 years ago, our staff has always been very passionate about the vertical enforcement program and the protection it affords the public by involving the lawyers to ensure the quality of the evidence that is produced in these investigations, because it is evidence that ultimately may be used in disciplinary prosecutions of physicians. The vast majority of our staff worked on your cases before vertical enforcement was implemented, including me. The prior model of lawyers and investigators working in silos did not work for this type of important work. I recall handling file cases resulting in de minimis discipline years after investigations were open due to the state of the collected evidence. And I feel we do a really good job identifying those cases very early on and dismissing them as appropriate and resolving them and allowing us to focus on very, very strong cases. With the Complaint Investigation Office in Ms. Kirchmeyer's headquarters, keeping about 300 investigations, which is the lowest level of complexity of cases a year, these investigations that the Complaint Investigation Office handles have been the types of cases that we agree are not going to benefit as much from the vertical enforcement program. They can include conviction cases, petitions to revoke probation, and things like that. We have been left in HQIU with the cases that should be vertically enforced because of the matters that are being brought by the patient and the severity of whatever the care presents. With HQIU also shedding 2 of my clients, we represent the Board of Psychology and also the Osteopathic Medical Board. They're shedding their clients and sending them to the other side of the shop. We hope to see investigations moving forward. We have started working on a subject interview training for investigators, and we have also offered to take some of the burden of scheduling physician interviews from HQIU. We could use our senior legal analysts, who are like paralegals, to do that. So then that way investigators, rather than chasing people down on the phone, they can focus on investigations and their important work. As required by the protocol, we do our part in HQE in identifying cases that don't need a DAG appearance at the physician interview. As investigators remain in HQIU and as they develop that skill, many times we're able to just send the questions to a talented investigator who's well-trained with areas to probe, and it doesn't require the DAG to show up at the subject interview. But throughout, we're directing your investigations.
Thank you. Dr. Kraus?
Thank you, Ms. Castro. Thank you. I must say, in the few short years I've been on the board, that I'm impressed not only with the skill and the compulsive nature of the Deputy Attorney Generals, but indeed with their passion. And it's nice to know that they care about the good work that they're doing. I'm also pleased to hear that you're working with HQIU to try to share some of the burden and help reduce the backlog. Are you hindered at any time by lack of adequate medical experts? Are we working hard enough to keep a large enough panel of medical experts, or does that sometimes really hinder bringing a case forward?
We have the most difficulty, Dr. Kraus, on very obscure areas like pathology or dermatology. So if we could enlist your help in finding those subspecialties within subspecialties, that's where we find the most challenge. Obviously, we are allowed to go off the script and pay a little bit more, but that is rare and far between. And the last time I saw that happen was about 5 years ago. We really couldn't find anyone on our list because there was no one there. Beyond that, what would be good, obviously, in my opinion, would be to pay the experts a little bit more by the hour. It would also be very useful for our staff, who sometimes is at the mercy of the Office of Administrative Hearings calendar and them listening to the entreaties of opposing counsel and respondent requesting last-minute continuances of hearings, that we be able to compensate experts who have cleared their calendars. It is very, very troubling to me that when we know we're going to go to hearing, that if we don't go, we can't pay the expert for the whole day that they cleared their surgery calendar. It's never going to put them in their rightful place, but it would be a good start to be able to say, if OAH grants a continuance within 5 days of when the hearing was going to start and the expert has requested, that we compensate them just on an hourly basis for the last-minute cancellation. And it's important because these are the same experts we're trying to convince to do the right thing. We have to do the right thing by them. And so if we could work with Ms. Kirchmeier on allowing the medical board to, it's just frustrating. Because here's the thing, when we set a hearing with OAH, it's usually at least about 180 days before we're going to go. We always ask the expert, hey, are you available this day? We may not go, we may settle, but I need you. And we work around the expert schedule. Obviously, though, Office of Administrative Hearings will continue hearings as necessary. You know, people get sick, experts aren't available for whatever reason. But if you're canceling a hearing on a Friday, it's not a call you want to make to tell the expert, hey, you know what, you could work on Monday. If they're a surgeon, they're not working Monday. And it's not about the money, it's just about the respect. So that's a challenge that I'm happy to bring to you to fix, Dr. Kraus.
Great.
And Dr. Yip.
Thank you.
Do you stay close in touch with Ms. Delp regarding areas where the expert coverage may be thin?
With Ms. Delp?
Um,
Probably not with Ms. Delp. I know that we have very close relationships with Ms. Getzinger, and we have been working a lot harder on trying to give Ms. Delp back some of our completed questionnaires on experts and, you know, how they presented at hearing, any feedback that we can give to the expert. We always send the experts the decisions and orders once we're done, because we believe it's very important to make them partners in the result, whether it's good or bad. I think it's always useful for experts to know how their opinion was perceived, how they came across, whether or not they were credible, and hopefully they'll want to do it again. It's a service-oriented interaction with our experts who we cannot do anything without.
Yeah. The feedback is important, both positive and negative, because an expert that's not doing his or her job properly can really hinder, you know, the case going forward.
That's right. And with Ms. Delp's help, I did find out that my staff was not taking that feedback as seriously as they should have at the tail end. They were maybe communicating it amongst ourselves, but we weren't telling the client, hey, you know, this is someone who did a fine job or was very helpful or, you know, yeah.
Thank you.
Thank you, sir.
Thank you. Any comment?
No.
Actually, I think, Ms. Castro, just to reiterate, we all appreciate your effort and passion. But as you say, sometimes actually it's not the money that count for the expert review, it's the respect.
Yes.
And when I approach the USC Dean's office, they're actually very excited about helping out. They say we can send out email, we can invite the special faculty that we want. I think sometimes you have problem getting expert, you may go through that channel and get someone that you really need. So thank you.
Right, it's always useful to involve the experts that have had a very positive experience back and to try and convince others to do it. They're not going to do it for the money, they're going to do it for the good of the profession and for the public.
Any comments from those in the audience? Comments from those on the phone?
Do we have any comments on the line?
And for questions, please press star 1.
No?
Not at this time.
We have no comments.
Thanks.
Right, thank you.
Thank you, Ms. Castro. We move on, agenda item 9, Ms. Delp and Ms. Houston will provide a presentation on the probation unit timeframes and action for violations of probation.
So before we get started, I just want to introduce Susan Houston. She's the new enforcement program manager that was hired by the board back in March, and she is over not only probation, but also the CIO and the discipline coordination units. I guess we'll just put it right there. Okay, so as you can see, we have a rather lengthy presentation. So hopefully we'll get through this. So the overview of the presentation is to go over the conditions that are in the manual model of disciplinary terms and conditions, the uniform standards of substance abusing licensee conditions, and what actions staff will take when there's a violation that occurs, and the timeframes to take those actions. Also, at the end of the presentation is some statistics about the probation unit. So the objective is to bring awareness of what actions are taken when a violation occurs, and then also the timeframes for those actions. And just to start with some statutory authorities, just to reiterate, public protection is paramount, and it is also the statutory authority that authorizes the board and the administrative law judges when exercising disciplinary authority is Business and Professions Code, Section 2229. When exercising this discipline authority, action should be aiding in rehabilitating the licensee or restrict the scope of practice or other restrictions as indicated by the evidence presented. The California legislature also set forth that the board shall seek out licensees who have demonstrated deficiencies in competency and then take actions as indicated to include further education, restrictions from practice, or other means that will remove those deficiencies. And a way to carry out those is by putting a physician respondent on probation. So to implement the mandates of Business and Professions Code Section 2229 and the California Code of Regulations Sections 1361 and 1361.5, which are the manual model of disciplinary guidelines and uniform standards. These guidelines are used to create the provisions that are then drafted to create the disciplinary order, which in turn becomes the responsibility of probation staff to ensure through monitoring that the physician respondent is in compliance with the terms and conditions of the order. So we're going to start with the manual model of disciplinary guidelines, and it's important to stress that these are guidelines that, depending on the circumstances, mitigating factors of the violation, not everything that we go over today is set in stone. They are guidelines. So the manual model of disciplinary guidelines, these conditions, as you know, can be deviated from. These guidelines are in the process of being modified. I think later on in the board meeting, we're going through a modification regulation process, and I guess we expect those new modifications to be coming out sometime in August, hopefully September. Some examples of those changes is that some of the guidelines, a probationer would no longer be able to retake the special purpose exam after failing it the first time. And then also out-of-state probationers will now be subjected to taking biological fluid testing. So today's presentation speaks to what is currently in existence of those guidelines. So the first optional condition that can be used is suspension, which is obviously a physician is barred from practicing medicine. So and a suspension could be example for 30 days, 60 days, however, a suspension cannot exceed 1 year. The suspension begins the 16th day after the effective date of a decision. And during suspension, probationer is still required to complete any courses, register for biological fluiding, and comply with the standard terms and conditions. So what probation staff does to ensure the suspension is being complied with is that they would drive by or call the place of employment. If the suspension is over 30 days, they will retrieve the wall certificate and the pocket license, and they'll even contact the Drug Enforcement Agency to let them know that they are barred from practicing medicine. If there is a violation for a suspension practicing without a license, within 24 to 48 hours, a referral is made to the investigation office, so the field office. We make a referral to the sworn investigators to further investigate the allegation of practicing medicine with a suspended license. And depending on the findings of that investigation, then an accusation and petition to revoke is transmitted to the Attorney General's office. And of course, that investigation timeframe varies. For controlled substances and the disciplinary guidelines, what speaks to related to control is conditions number 5 through 8. And that is where the licensee is prohibited from or limited from ordering, prescribing, administering, furnishing, or possessing a controlled substance. So for a total restriction, it's obvious that they cannot prescribe or do anything at all. And with that, also the surrender of a DA permit goes hand in hand. And they cannot practice medicine sometimes until proof is provided that the permit is surrendered and the prescription pads have also been surrendered. Partial restriction is where the probationer is limited in the types of drugs that he or she can order, prescribe, or dispense. And when that that happens, then DEA is also notified, and the petitioner may ask for his or her DA permit to be reissued, where it just specifies what restrictions that they have. Condition number 8, maintain records, also goes hand in hand with the partial restriction. And condition number 8 of maintaining records, the probationer is required to record a log of all scheduled drugs ordered, prescribed. The log must be available for inspection, copying at all times during the length of probation, and the log must record the name and address of a patient, the date of the doctor's visit, the type and quantity of the drug involved, indications and diagnosis for which drug was furnished. So what staff does to monitor this condition is they will verify with the DA that the permit and/or the prescription pads were surrendered. They notify the Drug Enforcement Agency of the drug limitations that they can only prescribe. They obtain proof from the probationer of their surrendered or reissued permit. They will run a cures report, and they also compare the cures report to the logs for compliance and see if there's any discrepancies. So when there's a violation of any of these conditions, say for ordering, dispensing drugs that they shouldn't be doing, within 24 to 48 hours, a referral again is made to the field office. They make a referral to the sworn investigators to investigate. Our sworn investigators are the only ones that have the authority to get certified copies of prescriptions, and this evidence is quite crucial to be able to provide to the Attorney General's office to take disciplinary action. And again, depending on the findings of the investigation, an accusation and petition to revoke is transmitted to the Attorney General's office, and again, those investigation times will vary. If the violation is the probationer does not provide proof of the surrender or reissuance of a permit, within a 3 to 5 business day time frame, staff will generate a noncompliance report, then also send a noncompliance letter to the probationer and asking them to comply within 5 days. And if they don't comply within 5 days, then a citation order with a citation and fine with an order of abatement would be issued. If there's a violation for not having the log that contains all the elements per the order, it doesn't meet the criteria, again, within 3 business days, staff will document in a noncompliance report, issue a noncompliance letter to the probationer, ask them to come in compliance within 5 days, and if they don't, another citation with an order of abatement would be issued. If there's a discrepancy between the logs and a CARES report, depending on the findings of that discrepancy, staff would, within 7 business days, they get an explanation from the probationer. They would contact the pharmacies to see if they can get confirmation if there was a potential violation. They would also then, if they couldn't get any information from the pharmacy, like I said earlier, they make a referral to the field office to assist because they're the only ones that contain, get certified copies of prescriptions. And then depending on the findings of that investigation, then they would make a referral, a transmittal to the Attorney General's office for an accusation petition to revoke. Conditions 9 and 10, which are abstain from use of alcohol and drugs. The probationers, just that, refrain from use of possession of controlled drugs, dangerous drugs, or drugs that require a prescription. And they are to refrain from use of products or beverages containing alcohol. When there's an abstain for drugs or alcohol, that also goes hand in hand with the biological fluid testing requirement. And these restrictions would not apply to medication that's lawfully prescribed to probationers by another practitioner for a bona fide illness. So within 15 days of receiving any lawfully prescribed medication, the probationer is to notify the board. And the notification must include the issuing practitioner's name, address and telephone number, medication name, strength and quantity, issuing pharmacy name, address and telephone number. So a probationer cannot test positive for any substance to include legally prescribed medication if they did not notify the board. So what staff does to ensure compliance with this condition is that they oversee, make sure they get the list of lawfully prescribed medications from the probationer, and they monitor the biological fluid testing that is conducted by the probationer and our laboratories. If there is a violation of a confirmed positive biological fluid test for drugs or alcohol, within 24 to 48 hours, staff will get an explanation from the probationer and starts to get explanation from the laboratory. And they'll start to obtain certified records from the laboratory. They'll complete a noncompliance report, and they would issue a cease practice order, and a transmittal would be sent to the Attorney General's office for a petition to revoke. We get an explanation from the probationer because we feel it's important. There could be perhaps, I think it's the last presentation when I did in January, say they got hurt and they did get a lawfully prescribed medication. They have 15 days to report that. So technically, if it shows up as positive, it really may not be a positive because they had 15 days to report a new prescribed medication. So there has to be some research that needs to be conducted. And then when a cease practice order is issued, the probationer cannot resume the practice of medicine until a final decision or an accusation or petition to revoke is rendered. The accusation, petition to revoke must be filed within 15 days after the cease practice order, and if a hearing is requested, then it must take place within 30 days unless the probationer requests a hearing at a later date. Okay, excuse me. So when there's a violation where they do not provide timely notification of a lawfully prescribed medication and there are positive tests, within 24 to 40 hours, we obtain the explanation, we issue the cease practice order. If it's determined that they lawfully were prescribed but they failed to report it, we would lift the cease practice order and issue a citation and fine. But if it was unlawful, then we would transmit to the Attorney General's office for an accusation petition to revoke. So for biological fluid testing, which is condition option number 11, probationers must submit to random, unannounced, observed biological fluid testing. Probationer needs to enter into contract with the lab. We can test for urine, blood, hair, or by breathalyzer. Probationers must be call-in between the hours of midnight and 5 p.m. They're required to call in daily to see if they are required to test, and when called to test, they must test that day, and all testing is at the probationer's expense. So probation staff, what they do to monitor this is they check with the approved laboratories database to confirm that they are compliant with calling in daily, and they receive alerts about positive tests, and then they get confirmation also from missed tests from the laboratories. So if the violation, the probationer does not call in daily within 24 to 48 hours, we will request an explanation from the probationer. Again, we look at what the reasons are. If perhaps there was a family illness or if they were ill, depending on the circumstances, we may not consider it to be a violation. But if it's not a plausible reason, within 3 to 5 business days, we would do a noncompliance report. And on the first offense of not calling in, they would get a noncompliance letter alerting them that the second time they would get a citation and fine. If the second offense occurs for not calling in, then we would issue the citation and fine with an order of abatement to continue to comply. And if there's a third offense, we could prepare a transmittal to the Attorney General's office for a petition to revoke for noncompliance. If there's a violation for not testing when requested, again, we ask for an explanation from the probationer within 24 to 48 hours. And then within 3 to 5 days, we would issue a noncompliance report. And on the first offense, we would issue a citation and fine. Second offense, we would issue a cease practice order and transmit to the Attorney General's office for petition to revoke. We need to demonstrate the progressive discipline and the pattern of failing to cooperate with the testing. And then if alcohol is the drug of choice, we might schedule a second test to go in and get a blood test. And if drugs have been an issue, we could schedule a hair test immediately after that.
We're going to go on to required courses. These are going to be options 13 to 17. It's the continued medical education, prescribing practices, medical record keeping, professionalism program ethics, professional boundaries program. So they must enroll within 60 days of the effective date of the order, successfully complete it no later than 6 months of enrollment. They must provide proof of completion no later than 15 days after completing the program. For the medical education courses, they must take a minimum of 65 credits each year. Breakdown is 40 credits satisfies this condition, and the remaining 25 satisfies a license renewal requirement. The prescribing practices and medical record-keeping courses, if required to take other components, have up to 1 year to complete. Ethics course, after completion within 6 months, does have a mandatory 1-year follow-up. Only the professional boundaries course has condition precedent options, such as can't practice medicine until proof of completion, or if fails the program, the board can issue a cease practice order. So violation, if they don't enroll within 60 days, within 3 to 5 business days, we're going to request an explanation from the probationer. We're going to issue a noncompliance report and a noncompliance letter, and we'll give them 7 business days to comply. Again, there could be extenuating circumstances that may grant an extension, for example, a death in the family, an illness, or a family emergency. If they're not complying, we're going to issue a cite and fine with an order of abatement. And again, if they still fail within 7 days of notification, we're going to do noncompliance and transmit the PTR to comply with order of abatement to enroll, or probably refer to AGO for PTR. Okay, for violation, if they enroll but don't comply within the time frame, or does not complete other components within the time frame, or untimely submission of proof of completion, again, within 3 to 5 business days, we're going to ask for an explanation. We're going to do a noncompliance report. Again, if they don't comply, we're going to issue cite and fine with order of abatement, or if still non-compliance, we'll transmit to the field for a PTR. Again, there could be extenuating circumstances, for example, an illness, family illness, death in the family, et cetera. Like probation enrolls but doesn't complete the course and or components within the time frame, we can issue, like, again, the cite and fine, order of abatement. And after non-compliance for an unacceptable explanation, they don't comply, we're going to transmit to the AGO for PTR. Or if they don't provide proof of completion timely, probation will send a non-compliance letter with 7 days to submit proof. And if they don't comply, again, cite and fine, order of abatement. Non-compliance with order of abatement, we're going to transmit to the AGO for a PTR. So a violation, if they don't complete the boundaries course within the 6 months with condition precedent, we're going to, within 24 to 48 hours, we're going to ask for an explanation. And again, we'll issue a cease practice order, and that cease practice order will remain in effect until the course is completed. Clinical training program, option 18. Enroll into a clinical training or educational program that assesses the probationer's physical and mental health, basic clinical and communication skills, medical knowledge. They must enroll within 60 days of the effective date of the order. They must successfully complete it no later than 6 months, and they must comply with the program recommendations. Some optional language: if they fail to enroll, participate in, or successfully complete within the timeframes, the board may issue a cease practice order, and they cannot practice until the enrollment or participation is completed. Number 2, if they didn't successfully complete and cannot practice until final decision rendered on the accusation in PTR. 3, within 60 days of successful completion, they must participate in a professional enhancement program. This program conducts quarterly chart reviews, semi-annual practice assessment, and review of personal growth and development. Or a condition precedent option, it'll say probationer cannot practice until they complete the clinical training program. So my staff will contact the provider to confirm enrollment and participation, and they're going to review the program's reports. For example, the neuropsychological exam, staff will set this examination up, and the staff will ensure compliance with all recommendations. So the violation, so the probationer fails to enroll within 60 days, or participates or completes the program within 6 months, or does not comply with program recommendations, within 3 to 5 business days, we're going to ask for an explanation. We're going to confirm the noncompliance with the provider, issue a noncompliance report, and issue a cease practice order. Again, we'll take in any extenuating circumstances that could grant an extension. Again, if we do a cease practice order, it will remain in effect until the probationer enrolls or participates in the program. If they don't comply, again, it'll be a cite and fine with order of abatement, and then we'll transmit it to the AGO for a PTR. If the probationer fails the clinical training program within 24 to 48 hours, we're going to issue a noncompliance report, issue a cease practice order, and transmit to the AGO for a PTR. Again, the probationer should not resume practice of medicine until a final decision has been rendered on the accusation in PTR. Psychiatric evaluation, option 20. They must undergo psychiatric evaluation and psychological testing if deemed necessary. Within 30 days, they must complete the psychological evaluation and psychological testing if deemed necessary by the board-appointed board-certified psychiatrist. They may be required to take further evaluations on whatever periodic basis thereafter as required by the board. Psychiatric evaluations completed prior to the effective date of the decision are not accepted. The cost of the evaluation is covered by the probationer, and the probationer must comply with all restrictions and conditions recommended by the psychiatrist within 15 calendar days of notification by board or designee. There's a condition precedent They cannot practice medicine until notified by the board that he or she is mentally fit to practice medicine safely. My probation staff will select the board-appointed, board-certified psychiatrist, review the report, and if condition precedent, notify the probationer if he or she is safe to practice medicine. Violation, again, if they don't undergo evaluation within 30 days and they don't comply with the recommended restrictions or conditions, within 3 to 5 business days, we're going to ask the probationer for an explanation. Again, extenuating circumstances could grant an extension. We're going to do a non-compliance report. And again, if they still don't comply, we're going to issue a cite and fine with order of abatement. And if still non-compliance, we're going to transmit to the AGO for a PTR. Psychotherapy, option 21. Within 60 days, they submit to the board the name and qualification of a board-certified psychiatrist or licensed psychologist. Upon approval, they shall undergo and continue psychotherapy treatment. Again, the probationer pays all costs for the treatment. My probation staff will review the qualifications. They'll approve the candidate. They'll ensure the therapist is submitting the quarterly reports. They're going to review those reports and make sure there's any evaluations or recommendations that the probationer is required to submit to. The violation, if they don't submit their therapist's name for approval to undergo therapy within 60 days, within 3 to 5 days, we're going to ask for an explanation. We're going to issue a non-compliance report. Again, after 7 business days, we're going to non-compliance letter. We're going to issue a cite and fine with order of abatement, or for, again, non-compliance, we'll transmit to the field for a PTR. Option 22, medical evaluation and treatment. They have to undergo medical evaluation within 30 calendar days, an evaluation by the board-appointed physician. Following the evaluation, they must comply with all the restrictions within 15 calendar days after notification by the board. If required to undergo medical treatment, probationer shall, within 30 days of notification, submit the name of the treating physician to the board for approval. Once treating physician is approved, they have 15 days to undergo the treatment. Again, the probationer will pay all costs for the medical evaluations and treatment. My probation staff will select the board-appointed physician. They're going to review the reports. They'll approve treating physician of respondent's choice if recommended. They're going to ensure that that physician, we receive quarterly reports submitted by them. We're going to request treatment records when necessary, and if there's a condition precedent, we'll notify the probationer if he or she is safe to practice medicine. For the violation, if they do not have the evaluation within 30 days, within 3 to 5 business days, we're going to request an explanation. We're going to do a non-compliance report, and again, we're going to do a non-compliance letter within 7 business days to get them to comply. If they still don't, we're going to issue a cite and fine with an order of abatement, and then we can issue a non-compliance letter and transmit to the AGO for a PTR. For medical evaluation and treatment option 22, if they don't comply with restrictions and conditions within 15 calendar days of being noticed, or they don't submit for approval the name of the treating physician within 30 calendar days of being noticed, within 3 to 5 business days, again, we'll request an explanation, issue the non-compliance report, non-compliance letter, 7 business days to comply. We can issue a cite and fine with order of abatement, and again, refer to the field and do enough for non-compliance. Or the other violation, if the treating physician does not provide quarterly reports to the board, within 3 to 5 business days, we're going to request an explanation. We will do a non-compliance report and do a non-compliance letter and give the probationer 7 business days to comply. And then if they still don't, we can do a cite and fine or non-compliance letter and submit to the field. For monitor, practice billing, independent individual monitors the probationer's medical or billing practices. My staff will approve the monitor of the respondent's choice. They'll ensure quarterly reports are submitted by the monitor and review those reports. For the violation, if they don't submit for approval the name of the monitor within 30 calendar days, or no approved monitor in place within 60 days, they have 5 days to submit the name of a replacement monitor. They have 15 days from the day the new monitor must assume responsibility of monitoring the duties. If they fail to do these within 60 days of the monitor resigning or no longer available. Excuse me. So within 3 to 5 business days, we can do it. If they within 3 to 5 business days, we can do a non-compliance report, a non-compliance letter. They'll give them 7 days to comply. So if they fail to provide the name within 7 days, rather than issue a cite and fine, we'll wait 60 days and issue a cease practice order.
On that one, well, I just want to clarify, that one is they have 30 days to provide the name and get in compliance, and then after 60 days, if they don't, then that's when the cease practice order would take effect.
Thank you. So option 24, solo practice prohibition. Probationer cannot engage in solo practice of medicine. So my staff will approve the office setting. They'll visit the office setting to confirm physician colleague is present. Regular communication with the colleague at the practice setting. The violation within 60 days does not secure employment in appropriate practice setting upon effective date of order, and when practice setting changes, within 24 to 48 hours, we'll do a noncompliance report and we'll issue a cease practice order, and that cease practice order will remain in effect until the appropriate setting is established. Option 25, third-party chaperone. Chaperone present while consulting, examining, or treating patients. My probation staff will approve the names of the chaperone. They're going to review the log or written notifications, and they're going to contact patients on the log to ensure the chaperone is present during visits. The violation, within 60 days, they don't secure an approved chaperone upon the effective date of order, or if chaperone resigns or is no longer available, within 24 to 48 hours, we're going to issue a cease practice order, and that order will be in effect until a chaperone is approved. Violation, if they fail to maintain an appropriate log within 3 to 5 business days, we're going to ask for an explanation, do a noncompliance report. We can issue a cite and fine with order of abatement, and noncompliance to the AGO for PTR. So these logs must contain the patient initials, address and telephone number, medical record number, and date of service. Prohibited practice, option 26. Guideline states verbal notification is required. However, guidelines can be deviated and order can require written notifications or above. So the prohibited practice from performing or treating a specific procedure, surgery, or prohibition on specific patient population. My staff will ensure their logs are completed. They'll contact the patients on the log to ensure the probationer is providing notification of prohibited practice to patients. For the violation, if they fail to provide notification to patients or maintain adequate logs, within 3 to 5 business days, we're going to ask for an explanation. We're going to issue a non-compliance report. We can issue cite and fine with order of abatement, and still non-compliance, we're going to transmit to the field for a PTR.
So that's kind of just giving you an overview of the manual model of disciplinary guidelines, the optional conditions. There are also the standard conditions, and these standard conditions are always within the disciplinary orders. Some of the standard conditions are notification, supervision of physician assistants, general probation requirements, quarterly declarations, as you can see. For the general requirements, they have to keep the board informed of their address change, business or residence change, email or phone number. They must maintain a current and renewed California physician surgeon license. Inform staff when their travel exceeds 30 days. Inform of residence or practice change in another state if it exceeds 30 days. Non-practice condition is within 15 days. They must notify us in writing if their non-practice exceeds 30 calendar days. And within 15 days, they have to notify us when they do return to practice. And periods of non-practice typically do not exceed 2 years. So to monitor the standard conditions, they just ensure that within the order, they're set timeframes, and they just continue to comply with those. But one of the critical ones I point out is that if a probationer does not practice medicine and it's exceeding up to 18 months, and they have to take a clinical training program, they will go ahead and submit to the Attorney General's office a petition to revoke if they haven't proceeded to take that. So they will do their noncompliance report, and depending on what the condition, the standard condition that's violated, they might issue a citation and fine, or again, like I said, issue a transmittal to the Attorney General's office to revoke probation. Getting into the uniform standards for substance abusing licensees, we're starting to see more orders that contain that language. And as you're aware, that these standards cannot be deviated from when there is determined that an individual is deemed to be a substance abusing licensee. So some of the conditions within this disciplinary guideline are the clinical diagnostic evaluation and reports. A board certified physician surgeon needs to conduct a clinical diagnostic evaluation of the probationer, recommend treatment, and recommend any restrictions or compliance that they need to also abide by. They need to notify the board within 24 hours if they feel that the person is unsafe. And the probationer needs to have at least 30 days of negative biological fluid testing while they're going through the clinical diagnostic evaluation. The notice of employer or supervisor, probationer shall provide the board with information regarding all employees and supervisors to whom that they work with, and written consent to the board for those names. And we are able to communicate with those individuals about the probationer's work status, performance, and monitoring. For biological fluid testing, we can order, it's the random testing that includes weekends and holidays that the probationer must take. And the frequency under this guidelines is within the first year, they can take 52 up to 104 tests. And then the second year, we can lower the frequency down to 36 to 104 tests a year, and that can remain for the life of the term of the probation. The support group meetings, within 30 calendar days, they submit the name for approval of their substance abuse support group, and they must attend this support group for the duration of probation. They must attend a minimum of once per week, and they pay all the cost. Worksite monitor, within 30 calendar days, they must submit a name of approval of a monitor. Respondent pays all costs for the monitoring. They have 5 days to submit the name of the monitor, and then 15 days after, they must assume monitoring responsibility. And they also have within 60 days, they must comply with this condition. So with the substance abusing licensees, disciplinary orders, they state in their minor and major violations. So a major violation, as you can see from the slide, I'm going to speed things up, I'm not going to read them all, but if they fail to undergo clinical diagnostic evaluation, they engage in a drug or alcohol-related act related to, while they're practicing, or fail to undergo biological fluid testing, what staff will do within 24 to 40 hours, complete their noncompliance report, and they have 3 alternatives. We can issue a cease practice order. We can also increase the frequency of their biological fluid testing, or we can make a referral to the Attorney General's office for further disciplinary action, or we can take multiple of these actions. So it could be one or multiple that we can take. For minor violations, if a probationer fails to submit the required documentation timely, fails to contract with a worksite monitor, is impaired, fails to comply with terms and conditions that do not impair public safety, those are considered minor violations. Within 24 to 40 hours, we will do our noncompliance report, and we have the options of issuing a cease practice order, imposing more practice limitations, increasing supervision, increasing their documentations, issue a cite and fine, require them to undergo a clinical diagnostic evaluation, or take other action as determined. With the substance abusing licensees, one of the difference is that we can impose those restrictions without having to file an accusation to get the discipline. And we've been issuing lately a few cease practice orders under this order and requiring individuals to have to go back to take clinical diagnostic evaluations or have increased their frequency lately because they have been not complying with their testing requirements. And so the last part of the presentation is just to go over some statistics. So as I stated earlier, in fiscal year 14-15, we've issued 9 cease practice orders, but in 15-16, we have increased to 14. And our transmittals to the Attorney General's office have increased from 20 to 36. And accusations that have been filed so far have increased also from 21 to 29. The next slide that you have, just a little bit more of statistics. It's broken down by the case type. I know at the last January meeting, it was requested to see some statistics on the number of physicians on probation and what was the allegations of the case type. So as you can see from there, we've got a total of currently 605 probationers. This data was gathered as of July 13th. So as you know, that number is very fluid. So it's as of that date. So just don't want to, keep reading it because we know we're taking up time. You can see the number there, and unprofessional conduct is pretty high, as well as gross negligence and incompetence for reasons why people are placed on probation. And then also in your attachment, again, data was, board members had asked for some data. There's the number of the physicians on probation, breaking them down to see currently if they're practicing in-state or out-of-state, and the terms of their conditions. Tells you whether an individual is like 3 years probation, the year that the probation was ordered, and the case type again, as to why they were placed on probation. So unless you have any questions, that concludes our presentation.
Dr. Kraus?
Ms. Delp, thank you. You and Ms. Houston did a lot of homework for that, and it's appreciated.
Yeah.
One of the things I reflect upon, and I think we touch on little bits of it every time we have a board meeting, is self-assessment, and by which I mean the board assessing itself in terms of its performance. In medicine, we have morbidity and mortality conference. When something goes bad, you sit down in a group and you analyze it. So I'm wondering if we have mechanisms within our board where if a member of the state of California has a untoward medical event, if we analyze that in some organized fashion to say, how did we miss this? Did a doctor do something wrong that could have been brought to our attention sooner? So in some respect, I guess what I'm asking is, what is our own internal quality assurance program like? Do we have benchmarks for quality indicators? So when we read about the board is supposed to respond within 24 to 48 hours if a probationer fails to do something, do we reflect on our performance in doing that? Are there some times when we fall outside of those parameters? And if we do, have there been any cases of untoward outcomes because we haven't done something properly or in timely fashion? So if they don't already exist, and perhaps they do exist amongst the staff, it'd be useful to develop a list of quality indicators of how are we doing. And by that, I don't mean simply, how many cases are older than 365 days or how many cases are older than 550 days, but also trying to tie those statistics of our own internal performance to whether or not there have been or may be circumstances where the citizens of California may not be as well served as they need to be in terms of our protecting them. And maybe that's too much of a question to answer today. Maybe that should be a subject for our next agenda in terms of looking at our own quality indicators and quality assurance program, informing us as to what it is and maybe if it needs to be improved, working on that together to improve that. But you're certainly welcome to respond at this time.
Okay. I think that's a great way to move in that direction. We have recently with our department, they're called performance measures. So performance measures are being implemented. I believe we started tracking them, but the statistics are not coming out yet. And when a violation is identified, staff is to record that into our system, and it will be able to give us an average time frame of when the violation has been noticed to when it actually gets pursued and actions taken. So we're starting to track those metrics, but definitely can expand beyond that. That's going to be implemented.
Thank you.
I was just going to continue on in that vein. I'm wondering if we could see what those PMs are, what those performance metrics are, because many times it's about the timing, but getting to Dr. Krause's point and our point of the board to protect the public, it would be good. I think we talked about it a little bit, and you allude to it about the triaging again. So we don't take the things that can stick at the bottom and do those because they're easier and faster, right? You've already demonstrated that's not the way you're organized. You're actually taking the things that are at the very top. But what you went through today, those imposed 60 days, someone will do something and they have a 24 to 48 hour. I think that's also instructive to do almost, once you get that data, a root cause as to why these things aren't maybe perhaps moving. So I would really like to see those if we could, those performance metrics, if everyone agrees.
Okay, a few questions also. We see the term psychiatry that we have board approved, board appointed. Do we have a pool of psychiatrists that work constantly with the board, that when the violate physicians who need to be evaluated, we immediately have a pool to go to, or more like they find their own and we check them out and then we approve them?
When our board appointed is we use our experts that we use even on our investigative cases. So our database of experts is we go into there and contact whoever's been approved to be an expert, and they would do the evaluations.
Do we have enough of them? Seems we're short of psychiatrists, right?
I don't know. I think in the board packet has maybe the number of our current experts. So I guess I would say yes and no. I mean, we are going to be beefing up with our recruitment to get more people to participate. I mean, I know Ms. Castro had stressed the concern is compensation, and I know that's something that the board continues to try to work on to get our experts compensated more, because I think that is.
Actually, that's my next question. Has there been any complaint from the licensee that we cannot get an appointment with your appointed psychiatrist, or I guess they would pay for that particular psychiatrist, right?
Actually, the board pays for it up front, and then they reimburse the board.
So we set the fee then.
Yeah, we paid in advance to get them into the evaluation, and they pay the board back.
And the other question about the cease practice order, the different kind of cease practice order for different kind, I guess, how the serious the crime or the violation is, that I'm just thinking there's days involved and email to the AG's office and issue a non-compliance report, etc. Is there a mechanism that our probation staff would actually monitor? For example, I mean, like put a sign on the door that your doctor cease practice, you cannot see patients anymore, or how do they transfer the patient care for continuity care for the patient too?
Well, our orders become public, the cease practice orders are public. As far as them having to post that in their office, that's not part of the disciplinary guideline. So whatever they would do in fashion of taking an extended vacation or closing their business down is how they would typically notify a patient that they are not practicing. It's not something that probation currently in our disciplinary guidelines is required to get involved in.
And Dr. Yep, I just want to follow up on the question on the experts. So when we use experts for our complaint side, the process, that's where we pay them by hour, and it's our set amount of $150 per hour and $200 for testimony. However, when they're doing these evaluations for individuals who are on probation, it's their standard set rate. So there's no hourly. So it has to be done, and then the individual does pay that full amount. So there's no problem with the expert getting less pay than what they would do under a normal individual coming to them. Does that make sense? Yeah.
Right. Well, I'm certainly pleased to have new energy, new blood coming on board to help us move along the probation. But also personally, I think this is the back end, the front end in the future. I also like to see we have more effort paid to encourage the hospital to bring a more 805 report. I have the feeling that the hospital has not been really doing a lot of public protection by forwarding the 805 report to us. I bring it up just because Ms. Castro mentioned earlier too. So, are there any public comments from those in the audience? Dr. Hawkins?
Hold on, we may have too many members in here. We're good? Okay.
Dr. Hawkins?
Thank you. Yeah, Dr. Hawkins, a member of the medical board. So I want to thank staff for putting this together. It was a bit burdensome and in detail, but what it does is it gives me, and hopefully it gives everyone who's in the room and reviewing this or hearing this, an idea what probation involves. So as organizations and we're part of those organizations, protect the public, are concerned about probation and is it effective, what it involves. It's a very, very important perspective of what probation actually involves. It's pretty complicated with very, very specific timeframes and that sort of stuff. So it's very, very valuable. Thank you very much.
Thank you. Any more public comments from those in the audience?
Ask a question.
Please.
I'm Carol Moss, and just speaking on behalf of the public, I was just curious to see all of these new developments. Are they going to be retroactive on existing probationary applicants, or is it just going forward?
Well, if a probationer is currently on probation, all of these guidelines that we just talked about or actions would be in effect for them.
Great.
Yeah.
Thank you.
Thank you. Any comments from those on the phone?
Do we have any comments on the line?
Yes, we do. We turn to the line of Genevieve Clarval. Please go ahead. Your line is open.
Yes, I wanted to know if you know how many people violate their probation. How often does that happen? Or that's very rarely, or are you keeping track of that?
Can you hear?
What's the question, number of people that violated probation?
Yes.
Let me see what. Well, I don't know if I have the exact number because it doesn't include our, I guess, rotation and fines right now, but cease practice orders, like I said, we've already, in 15-16, have issued 14 and transmitted 36 cases. So those would be numbers of people who have violated probation. I don't have the cite and fine statistics with me, and also, obviously, we've already taken action already in this fiscal year, 16-17, and there's already been a lot of cease practice orders and petitions to revoke that have also been submitted. So I don't fortunately have the exact number.
Oh, well. Any comments from those on the phone?
Any additional comments on the line?
We have no further questions in queue from the phone lines.
Okay, thanks. So move on, agenda item 10. Any members have agenda items for the next enforcement committee meeting? Dr. Kraus?
Yeah, I'd like to see us have staff report and discuss quality indicators and quality assurance program for board performance.
Great. Dr. Bowman?
I concur with Dr. Kraus.
Great, thank you. Are there any public comments from those in the audience on future agenda items? I see none. Are there any comments from those on the phone for future agenda items?
Do we have any comments on the line?
Oh,
Please press star then 1 on the phone if you'd like to queue up for a question or comment.
we do have one.
Thank you.
It's on a non-agenda item.
Is it for the future, though? Is it?
One moment for the comments on the line.
Yeah, this is a non-agenda item.
No, it's for the future agenda item.
I don't know.
Are you saying that you missed,
It's not on a future agenda. I'm not sure if it's a future agenda item.
are you trying to open up agenda item 2, public comments on items not on the agenda?
It was my understanding that there is a time in the board meeting where we can bring forth public comments that are not on the agenda, and it's my understanding that you won't be able to make a comment on them either.
Do you mean to be speaking to the full board? This is the enforcement committee. The full board is
The
going to
full
start.
board.
Okay.
That's what I thought I was
If you,
waiting for.
in just a few minutes.
Perfect. Okay, that was my understanding. Sorry
Thank you.
about that.
Thank you, thank you. Okay, so the.
There's a comment
the
on,
phone-
do we have any comments on the line? Greg, the comments on the line?
We have no questions in queue.
Okay, great, thank you. Now we move on, agenda item 11, adjournment. So move, and second, okay. Thank you.
Okay, we're starting. Good afternoon. My name is Dev Ganadev. I'm the Vice President of the Medical Board of California. And Mr. Serrano Sewell, President of Medical Board, could not be here because of a long-standing obligation, so I'm going to run the meeting. So I have a few announcements. I want all of you to please turn off your cell phones to silent and make sure they are off the table so we can avoid feedback noise. You may notice board members accessing their laptops or tablets during the meeting. They're using the laptop solely to access the board meeting materials that are in electronic format. We're trying to save some trees. This is an official business meeting of the Medical Board of California. As such, disruptions of the board business will not be tolerated. We have a designated time on the agenda for public comment and ask for public comment on each agenda item. I ask that you be respectful of the need to conduct the board's business. Should anyone disrupt the meeting, I will ask the person to conduct himself or herself in such a manner that permits the board to transact its business. This meeting will be available via teleconference. Individual listening to the meeting will have an opportunity to provide public comment and will be assisted by moderator who will be facilitating teleconference process. For those members of the public participating via teleconference, please wait until the moderator has introduced you before you make your comments. To request to make a comment during the public comment period, press star and 1. You will hear a tone indicating you are in the queue for the comment. If you change your mind and do not want to make the comment, please press the pound sign. Assistance is available throughout the teleconference meeting. To request a specialist, press star 0. Each person will be limited to 3 minutes per agenda item. And during agenda item 2, public comments on items not on the agenda, the board has limited the public comment period for individuals and people present here to 20 minutes. During public comment on any other agenda item, 10 minutes will be allowed for comments from individuals on the teleconference line and those in the audience. After 10 minutes, no further comments will be accepted. Business services staff will be assisting me with receiving the public comments via teleconference during this meeting. The board welcomes public comment on any item on the agenda, and it is board's intent to ask for public comment prior to the board taking action on any agenda item. If, for some reason, I forget to ask for public comment on the agenda item, and you wish to speak on that item, please raise your hand or come forward and you will be recognized. And Ms. Webb will be reminding me anyway. I would like to request all speakers complete a presenter slip so I can call you by name at the appropriate time, and the record of this meeting can be full and complete. However, this is voluntary. Please give speaker slip to Ms. Stoof. Ms. Stoof, right there. I will do my best to call upon everyone who has supplied a slip for the agenda item and recognize those who wish to make last-minute comment. I want to remind all speakers to please stay on the topic and keep your comments to 3 minutes or less. We plan to end the meeting today at 5:30 p.m. I would also like to introduce Kim. Kim will assist with individuals in the audience to introduce. I would like to call the meeting to the order and ask Ms. Stoof to please roll call. Thank you.
Dr. Bolat?
Present.
Dr. Bishop?
Here.
Judge Feinstein?
Here.
Dr. Hawkins?
Here.
Dr. Kraus? Ms. Lawson? Dr. Levine? Dr. Lewis?
Present.
Ms. Pines? Mr. Serrano-Sewell? Ms. Sutton-Wills?
Here.
Mr. Warmoth?
Here.
Ms. Wright?
Here.
Dr. Yip? Dr. Gonadev?
Here. Thank you. Thank you, Ms. Stoof. Moving down to agenda item 2, public comments on items not on the agenda. Oh, this one. All of them. Okay. Okay, I have 1, 2, 3, 4, 5, so please, 6. So please try to keep your comments to 2 minutes. Thank you. The first one is Leonard Sapoto, MD.
Is make a presentation about a law that is now in effect by the Department of Health that now affects all doctors who practice oncology, because it is a felony in the state of California under that public health law to practice any kind of medicine with the exception of chemotherapy, radiation, or surgery. which means even immunotherapy or diet or exercise would be a felony. So the Department of Health has the right to be able to come to any doctor who's practicing any of these approaches and make it a criminal allegation. So what I would like to show you is what I've presented you with is a bill that was put into law back in 2005 that says that any doctor can practice any therapy that he or she wants, so long as they first offer the mainstream approaches, does a proper physical examination and history, and doesn't do any harm to the patient. So already we have the means that we need to regulate doctors who do anything in any field of medicine. So this Department of Health law is unnecessary. It interferes with doctors in the state of California to be able to practice the way they want to under the laws and regulations of the medical board. And so what I'm appealing is for you to support legislation with the intent of passing new legislation that would take this particular item out of the Department of Health's jurisdiction. So I realize that there isn't a bill that has been presented yet, but if we have the intent of the board to support this, it would make it a lot easier to find somebody in the Assembly who would support this bill and take it on and take it to the people so we can make a law out of it. So that's my request. And I'd like to be on the agenda at a future time to be able to have you vote on that or discuss it first.
Thank you, Dr. Saputo. Next person is Janice Miller.
Can I have members of the public sit at this table here? That has your timer on it.
Can you hear me okay? So I'm a little nervous, first time I've spoken in front of you. But I'm here for reasons to talk about SB 277 and medical exemptions. Thank you for listening to me. My talk is about 2.5 minutes, so hopefully you can give me the extra 30 seconds. On June 29th last year, Senator Pan clarified the intent of SB 277 to the California State Senate before it voted. The law included an amendment allowing medical exemptions based on the recommendation of a physician, and that family medical history, may be considered to determine whether the vaccination is appropriate for the patient. Even as he shepherded this legislation through, he knew about the CDC whistleblower who came forward with an admission of fraud eroding the public confidence in the vaccine program. On a separate occasion, Ben Allen specifically stated that doctors not be sanctioned or impacted by using their discretion for granting a medical exemption, and anyone who has a legitimate medical concern, he said, can get one. They are in the physician's judgment. Under the letter of the law, doctors can write medical exemptions, but there is a lot of pressure in the medical field not to give them. I understand that 99.9% of children under federal guidelines do not qualify for a medical exemption. We know vaccines harm. Otherwise, the pharmaceutical industry would be liable for those products. And we know that $3 billion has been paid out in death and injury claims by the Vaccine Injury Compensation Program. So that in itself proves that it's true. They do harm some. So these conditions put a lot of pressure on every licensed physician in California. SB 277 does not contain a provision that allows school districts, health departments, or anyone else to review or reject a physician's medical judgment. But it's happening. It started with the Santa Barbara Medical Exemption Pilot Project.
Please conclude.
Thank you. These actions not only violate SB 277, but as I understand, may also violate many federal and state privacy laws. So, 2 more things I want to bring. With the machine in place to trump every medical exemption, trust in our legislators, our medical community is eroded. Freedom as we know it has ended with SB 277. And I've come here today to ask each of you to support my right, to support all of our rights to make informed medical decisions with our doctors about vaccination, without coercion, without the threat of investigation due to complaint or loss of medical license, to let doctors use their judgment to write a medical exemption without risk. Thank you.
Thank you, Ms. Miller. The next person is Jessica Butcher, it looks like. Forgive me if I butchered your name.
I'm very used to it.
I have the same problem, so go ahead.
I'm also here to speak on SB 277, and I will try to keep my comments so that they aren't overlapping too much with this, who spoke before me said. I'm also, I'm here because the letter that Dr. Charity Dean sent out really raised a lot of red flags for me. And if you are not aware, on June 6, 2016, she sent out a letter stating to all school superintendents, principals, and child care center directors to send all medical exemptions for a, quote, comprehensive review of each exemption for the purpose of data collection and compliance with SB 277 criteria, excuse me. When Governor Brown signed SB 277 into law, he explicitly stated the legislature specifically, or excuse me, he explicitly stated that the legislature specifically amended SB 277 to exempt a child from immunizations whenever the child's physician concludes that there are circumstances, including but not limited to, family history for which the physician does not recommend immunization. Given that the governor has stated, it is clear, given what the governor has stated, it is clear that there is no need for Dr. Dean to perform a comprehensive review of each exemption, as she is not the child's doctor. She has absolutely no reason to burden the schools or anyone else with any additional steps, as the child's doctor has already concluded that the medical exemption is warranted, which is exactly in line with what Governor Brown has stated when he signed the bill into law. It is my summation that Dr. Dean and other department heads are using their positions to circumvent the explicitly stated authority of the child's physician. I respectfully request that you tell her and others in her position to stop usurping the law. Thank you.
Thank you, Ms. Butcher. Next person is Christina Hildebrand.
My name is Christina Hildebrand. I'm from A Voice for Choice, which is an organization that advocates for people to have informed choice and transparency of anything that goes into their body. I too am here to speak about vaccinations and the role that doctors have in writing medical exemptions. When you talk about vaccines, especially to doctors and many doctors, it's a taboo subject as a consumer, as a patient. But it's something that, most doctors will say they're safe and effective, but they're not 100% safe and effective. And there are children and adults who do get injured by these vaccines. Unfortunately, there's no way of telling or explicitly telling which child is at risk or which adult is at risk and which one is not from the vaccines. The vaccine schedule that the CDC has, the 72 doses by the age of 18, has never been tested in its entirety to see whether it is completely safe. I see two issues here that I would like you and I ask you to look at. One of them is that the insurance companies are giving kickbacks to doctors to have their children that are under age 2 or by age 2 fully vaccinated. There is up to $400, maybe even more, being given for every child that is vaccinated fully, which means that doctors are not looking at whether a child, what the risk and the benefit is, they're looking at their bottom line. $400 is a very nice amount per child under the age of, or who gets to 2 and is fully vaccinated. So I'd like you to look at the Stark Act and the kickbacks that those doctors are getting for fully vaccinating their children, and whether they truly are looking at the risks and the benefits for each and every child. The other thing that I see is that there is no recourse for patients who do get injured, not severely injured, but just have a seizure or have some reaction to a vaccine, because under the Vaccine Compensation Act, you have to have had an anaphylactic shock or have died from the vaccine to have to go to that program and request for monetary compensation.
Please conclude.
I will. So the other piece of it is that there are many doctors' practices that are now throwing children out of their practice because they are not 100% vaccinated, which again, if you're looking at each and every child and looking at the risk and the benefit of a vaccine for that child, you need to have a doctor allow children in there that are not 100% vaccinated. And that comes from either the corporations that they're working for, such as Kaiser or Stanford or other larger corporations having a say of you must have vaccinated children, or from the insurance companies. And what that leaves you with is a very few number of doctors who are in private practice, don't take insurance, who are willing to look at these children holistically. So I ask you to do those two things. Number one, to look and investigate the kickbacks that doctors are getting. And number two, really look at whether the doctors are doing no harm by having the children 100% vaccinated in their practice, because 100% of children
Please wrap
should
it
not
up.
be vaccinated. Thank you.
Thank you, Mr. Lebrun. Next one is Andre Angelantoni.
Good afternoon. We each have a 2-minute comment. Thank you for the opportunity to speak with you today. So good afternoon. My name is Andre Angelantoni, and I'm a resident of San Francisco. Though I'm not in medicine, I have a Bachelor of Science degree, and my science background includes being a co-author of 2 academic papers, including one in the Philosophical Transactions A of the Royal Society. So I do have some experience in how to gather rigorously evidence for a hypothesis. I plan on being a parent one day, and I intend to discuss the scientific basis for permitting parents to work with their doctors to choose whether and how much to vaccinate without mandates. Specifically, I'm going to talk about recent advances in our knowledge of how repeated immune activation due to aluminum adjuvanted vaccines may cause vaccine injury, including autism. It's commonly thought that vaccine injury is limited to some soreness in the arm, a slight fever, and in those allegedly rare 1 in a million cases, some paralysis or even death. Injury rates are currently seen to be so low that the benefits of vaccination far outweigh the drawbacks. In most people's minds, autism is absolutely not caused by vaccination. Fortunately, recent work by Caltech, UC Davis, and other groups is providing us the biological mechanism behind much vaccine-induced autism. Their work is showing how, first, maternal immune activation increases interleukin-6, and that is strongly pointing to the biological mechanism. It's long been known that infection during pregnancy causes autism and schizophrenia, and it wasn't the infection per se, but the mother's immune reaction to the infection that caused it. In 2005, Vargas et al. At Johns Hopkins showed that most brains of the autistics they autopsied were inflamed. In 2009, Caltech tested the theory that purposefully elevating interleukin-6 would cause inflammation. They found the mice exhibited autistic behavior.
Your time is up. Please conclude.
In 2014, Caltech partnered with UC Davis and performed the same experiments. By elevating interleukin-6, they were able to produce autistic monkeys. Emily will continue.
Good afternoon. Thank you for your time. My name is Emily Bentley. I have a Bachelor's of Science in Kinesiology, and I am a successful business owner in Berkeley. I am also a mother of a child who is partially vaccinated and is not able to attend kindergarten. To continue on some of Andre's points, other groups corroborated the maternal immune activation work. Panita's group at the School of Medicine at UCLA published their work with mice and stated that interleukin-6, IL-6, is necessary and sufficient for producing autism in offspring. Wise group at the New York Institute for Basic Research replicated Patterson's work and showed that elevating interleukin-6 via a genetically modified virus caused autistic behavior in postnatal mice. This evidence shows that elevating interleukin-6 will cause autism. What else raises interleukin-6? Aluminum adjuvanted vaccines. Up to 60% of the vaccines on the CDC infant and childhood immunization schedule include aluminum adjuvant. Aluminum is included to activate the immune system, and without it, the body would not recognize the weakened antigens and would not create the necessary antibodies. Vaccine adverse reactions can stimulate enormous IL-6 production in the brain in the same amount that causes brain damage in experimental animals. The studies supposedly disproving the link to autism consider only the MMR, measles, mumps, rubella vaccine. Aluminum-containing vaccines have not been studied, with the exception of hepatitis B, which is strongly associated with autism. Also, an epidemiological study by Shaw's group shows that exposure to aluminum from vaccines is associated with autism within the United States and across 7 developed countries. Vaccine promoters are using the MMR studies to argue that all vaccines have been proven safe. But this is dishonest and a misuse of this science.
Please conclude.
Vaccines are different, and the MMR does not contain aluminum. There is powerful scientific evidence for the mechanism by which and the ingredients in vaccines causing brain damage and autism. I urge you to consider these facts when conducting reviews, as physicians must be free to practice medicine in view of the latest science and how it relates to an individual's care. Thank you for your time.
Thank you. Thank you, Mr. Angeloni, and thank you, Ms. Bentley. Are there any other?
Actually, if I can just say, we did give some handouts with the citations for the mice and monkey studies. We'd like to respectfully request that the board receive them.
Thank you.
And those were handed out to the members.
Thank you.
Any other public comment from people who are here? If not, comment on the phone.
Do we have any comments on the line?
Yes, we do. We turn to the line of Gene Dorio. Please go ahead. Your line is open.
Thank you.
Go ahead, please.
Great, thank you. My name is Gene Dorio, D-O-R-I-O, and I am a licensed physician in Santa Clarita, California. Thank you for allowing me to address the medical board today. You know, I've been at Henry Mayo Hospital and seen their HMO hospitalists not provide standard of care to their patients, to their ill patients. The chief medical officer, a hospital administrator and California licensed physician, changes policies and procedures resulting in the deaths of patients. The hospital board of directors...
Doctor? Doctor, forgive me.
Yes.
But if this is a matter that may involve a complaint that may come before the board members, it's not appropriate to go into specifics.
Complained already. This is not a complaint. This is a statement. Hopefully you will bring this to your agenda or have it in committee. So they are not, these are things that I have found that I'm alluding to so that I can present this and makes more sense to you.
Is this involving a specific matter? Because it sounds like it.
It is very general.
Okay, just don't go into specifics, please.
Well, they weren't specifics; they were general.
Okay, it sounded like it was going down that path.
If I were giving you specifics, I would give you names and dates, which I can do, but I have elected not to.
Yeah, you've identified the hospital, so that's the concern.
Well, in Santa Clarita, and we only have one hospital here, so it would be very easy to figure out which hospital. I'm sitting in their parking lot right now, So if you had GPS on me, you would know
Please,
that's where I am. You know, so I
please
will-
continue
I
with
will
your
refrain-
comments.
I will
Please start his
refrain
time again.
to the hospital.
Please continue.
Should I continue?
Yes, please.
Good, thank you. I appreciate it. In addition, I've seen doctors who place their patients, elder senior patients, on hospital just for the benefit of their organization's financial needs. Outside the hospital, as described in 60 Minutes, there have been continual denials of requested medical care by California licensed physicians employed by insurance companies. They have been not held accountable for their practice of medicine under the guise of utilization review. I sense the California Medical Board might recognize utilization review lies within the realm of the practice of medicine, but seemingly to me, you are awaiting California legislators to define your legal jurisdiction. The highest priority of the medical board is to protect the public and should not wait the intrinsically slow legislative process. Plus, any new laws will have fingerprints of lobbyists and special interest groups, forcing the board to continually clarify complicated wording through your legal counsel. The Medical Practice Act might provide a legal tool to fulfill your fiduciary responsibilities for the purpose of appropriate patient care. I'm not an attorney, but Section 2018 may allow oversight of licensed physicians who are not practicing standards of care medicine. This discussion needs to take place as public confidence in physician medical decision-making has eroded because of business intervention. The unscrupulous and sometimes immoral practice of medicine influenced by profit must be deterred. Other than your board, there is no other California agency that can wield this power and lift the standards of medical care for the public services. The public has no place to turn, or do I? I hope the medical board will find a place on their agenda within a panel or an advisory committee to bring these issues forward. Thank you.
Thank you, Doctor. Any other comments on the phone?
We have no further comments on the phone lines.
Thank you. Now we go to agenda item 3. Oh, I'm sorry. Oh, we have? Yeah, please. Identify yourself.
Yes, I'm Eileen Ellis of San Francisco. Thank you for this opportunity to speak with you briefly today. I'm a mother of 2 boys, ages 5.5 and 9. I'm here today because I'd like to see SB 277 reformed, and I see that my rights as a parent and those rights of my children are being violated. You see, our family has significant history with autoimmune dysfunction and neurological dysfunction. We are also concerned about aluminum vaccines, the body's known challenges in processing it, and the effects of aluminum on a young child developing body when given multiple vaccines at one doctor's visit. Because of this and family history, we made an informed decision to vaccinate our children on a delayed, one-at-a-time schedule. And while my older son has a neurological concern and has been on hold on vaccinating orders for over 6 years, my younger son, who is so excited to go to kindergarten in 2 weeks, may be denied entrance at his brother's SFUSD elementary school because he is 5 vaccines away from being compliant with SB 277. By maintaining SB 277 in its current form, the state of California is violating my children's rights, children who are dependent on their parents to consider family history and apply healthcare choices we see necessary to support lifelong health and vitality. I ask the California Medical Board to work to adjust SB 277 in consideration of families like mine. Thank you.
Thank you. Well, last chance. Any other public comment on items not on the agenda? Okay, that item is closed. Item number 3, approval of minutes of May 5 and 6 meeting.
I move to approve the minutes.
Okay, please go ahead.
On page BRD 3-5, agenda item 8, that Ms. Birchmeyer stated the FSMB would also be taking a look at physician
All right, Dr. Cross, you're excused. You need to take some English lessons.
Nice comeback.
Any discussion? Any public comment from the audience? Any comments on those on the phone?
Do we have any comments on the line?
No, we do not.
Thank you. Ms. Toof, roll call, please.
Dr. Bolat? Aye. Dr. Bishop?
Aye.
Judge Feinstein?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus? Ms. Lawson? Dr. Lewis?
Aye.
Ms. Sutton Wills?
Yes.
Mr. Warmoth?
Aye.
Ms. Wright?
Aye.
Dr. Yip? Dr. Gonadev?
Yes.
Thank you.
Okay, now we'll go to the item we are waiting for a little while. Item number 4, presentation on the End of Life Option Act. Our speaker today is Dr. Grube. Just a little brief introduction of Dr. Grube. Dr. Grube was born in Eugene and raised in rural Oregon and Alaska. He received a BA cum laude in natural science at Lewis and Clark College in Portland, Oregon. He spent most of his senior year abroad studying public health in Austria. He graduated from the University of Oregon Medical School. In the third year, there he received a AAMC USPHS scholarship, fellowship to the former Yugoslavia, where he witnessed a smallpox epidemic in Belgrade. Dr. Grube completed his internship in Tucson, Arizona, and then became a commissioned officer in the United States Public Health Service. He was stationed in Grand Coulee, Washington for 3 years and moved to Philomath, Oregon in 1977, where he founded Philomath Family Medicine. He practiced family medicine there for 35 years, retiring in 2012. He was board certified in family medicine 1977 to 2015. He has been a leader in the Oregon Academy of Family Physicians and was the founder of CAFP Foundation, OAFP, California. Always stays in my mind. OAFP Foundation. He was appointed to the Oregon Board of Medical Examiners, now Oregon Medical Board in 2001, and served 7 years, 2 years as the chair. He was chosen OAFP Family Physician of the Year in 1986 and Oregon Medical Association Doctor Citizen of the Year in 2009. Dr. Grube has taught paramedical and medical students for his entire career. He has lectured nationally on topics such as professionalism, medical ethics, end-of-life care, and humor in medicine. He has served his local school board, his local hospital board, and is again on the board of local hospice. He is National Medical Director for Compassionate Choices for Oregon. Dr. Grube, please go ahead.
Thank you very much for the invitation to come speak with you today. Greetings from Oregon, and a special greetings from the Oregon Medical Board, particularly Executive Director Kathleen Haley. And in Oregon, we have a medical director, which you don't have in California, but Joe Thaler also wants to welcome you. And I want to particularly thank Kim Kirchmeier for all the support that she's given me to come today and in our discussions about your new End-of-Life Option Act, which is similar to the Oregon, what we had called Death with Dignity Act. And what I hope to do today was to educate you a bit about this act as it's integrated into the Medical Practice Act of California, and answer any questions that you might have. My idea is that we have experience in Oregon of about 18 years of what this act has meant for us, and because I was on the Oregon Medical Board, I understood that impact, which, by the way, is very small. So that my goals today are to review the medical aid in, the idea of medical aid in dying, the Oregon revised statute, and I'll be very short about that. Review your California End-of-Life Option Act, which is essentially the same. It's really, there's very few differences. We'll talk about them. And discuss future implications for the Medical Board of California in this regard, and then I hope to answer questions. I know you have a lot of work to do, and so I'll try to keep my comments brief. And the first thing I was going to say, and I forgot to say, but I wanted to thank each of you, every one of you, for your service to citizens of the state of California. Very few people know how hard it is to be on a medical board and do the work that you do. I happen to know because I was on the board, and it's an unbelievable amount of work, and thank you for what you're doing. I got the sources of information that I'll provide with you today besides my own personal experiences come from our state epidemiologist, who is Katrina Hedberg, as I mentioned, our Oregon Medical Board, and George Amy, who is an attorney and was a legislator who was one of the people who drafted the Oregon Act and also consulted your assemblymen and senators in California when you drafted this act as well. I have a few hats, and your acting chair mentioned them, so I'll skip that. But I want to remind us why we are here, and it's really about medicine and to cure sometimes, to relieve often, but always to comfort. And my opinion, and I guess I'm sharing this mostly with the non-clinicians in the room, and I know your board has way more lay members than we have in Oregon. In Oregon, we only have 2 lay members, and I think you have 7. So that's great. But anyway, in end-of-life care, in my mind, and this is my perspective, is to care for the patient. This is what licensees should be doing, California doctors, to teach the patient and their family to respect the wishes of the patient and to comfort and alleviate suffering. When I went to medical school, this is what I thought I would do, is that I would keep all my patients alive forever. And of course, after I practiced for a long time, I realized that that's not the case. We're talking about end-of-life care, and this End-of-Life Option Act discusses that. End-of-life care has many complements. It has full treatment, take everything that you could possibly do. Atul Gawande talks about that in his book, Being Mortal. Declining treatments, some are all treatments. That's patient autonomy, has the right to do that. And we have a lot of unwanted medical care because we doctors don't explain in shared medical decision-making what the outcomes might be. Hospice and palliative care, I am on the board of a hospice, and I believe in hospice strongly. Stopping eating and drinking, terminal sedation, which palliative care doctors do on rare occasions, and then medical aid in dying, which is what we're talking about today. This is not an end-of-life option. If I'm ever on life support, unplug me, then plug me back in and see if that works. The art and science of medicine include these things: patient autonomy, shared medical decision-making, and professionalism, professional integrity, and then our personal beliefs, which impact our decisions whether or not we would be a part of this. Medical aid in dying is now legal in 5 states, 4 states by referendum and legislative vote, and in Montana from action of the Supreme Court. This is something that I projected, and I don't know that it's true, but anyway, we're a little state compared to you, about 1/10 of you, maybe 1/9 of what you are. And in Oregon, we get about 3,500 requests for information regarding aid in dying, which we call Death with Dignity in Oregon. So I would imagine that in California, you're going to get 30 to 50,000 questions a year about this. And so that's why we all need to understand what it is and how to answer the questions. We have 18 years of data and experience, and that's what I bring today as an Oregonian to share with you. The problem I have with our law is that it's called Death with Dignity, and I think the dignity is defined by the individual, not by a law. And so I think your law has a much better name than ours, because if you're dying in the ICU with all the tubes in you, and you believe that that's what you want, and that could be dignified for you. So choosing any option could be dignity. But anyway, there's 5 components to these laws, to your End-of-Life Option Act and to our Medical Death with Dignity Act in Oregon. The 5 components are that you need to be a resident of the state of California, that you need to be 18 years or older, that you need to have a terminal diagnosis as determined by 2 different physicians, that you need to be volitional, it's your choice, it's no one else's choice, patient autonomy, and that you have to be mentally capable, decisionally capable in this regard. So the law that you have in California, which is similar to the law in Oregon, tries to outline protections for the citizens of the state to make that be, all of those components be present. It requires 2 physicians. It has to be either an allopathic physician, MD, or osteopathic physician, cannot be a chiropractor or a naturopath. One physician is the treating physician or attending physician. The other physician is the consulting physician. If either of them uncover a mental illness that has an impact on the patient's condition, then a third physician should be consulted, and that would be a psychiatrist. And all of the two main doctors must confirm the patient's eligibility in those 5 components that I mentioned to you. There's a process that you go through. There are 2 oral requests from the patient, and these must be at least 15 days apart. There is a written request after the doctors have evaluated the individual, and the written request has to be signed by 2 witnesses, and then the prescription could not be written until 2 days after the written request has been completed. The physician, the attending physician, treating physician, needs to inform the patient of all feasible alternatives, and this must be documented in the record. The alternatives of hospice care and palliative care and pain control. And he should or she should request that the patient notify the family, although that's not a requirement. There are forms that we have in Oregon that are similar forms that will be in California that the doctors must send in and complete. And I'm going to talk about that a little bit more in a second. It's a little different in California than it is in Oregon. And the pharmacy should be called and notified, and then there are follow-up forms after the patient has died. A few little statistics for you, and these are just some information that sometimes surprises people. The main take-home points that I want to share with you is that this is a rare thing in Oregon. We've had it for 18 years. It's still less than 0.3% of deaths, and that fully a third of people who get the prescription do not take it. 1/3 of people who get the prescription, and therefore, in my opinion, and the opinion of a number of other people, this is a palliative act. Just getting the prescription is a palliative act. This graph demonstrates that thing that I just mentioned, that in the green are the people who actually took the medication, and in the blue are the prescriptions that were written. And so while it has increased over time, as has the population of Oregon, we're growing very fast, it's still between 0.2 and 0.3% of deaths per year, very rare, very uncommon. Last year, for example, we only had 218 prescriptions written. They were written by 106 different doctors. The wonderful thing about this as a possible consequence is that our hospice penetration and use has increased dramatically, and now we have 92% of patients who choose or consider aid in dying are in hospice, get to die at home, and for the most part, these are people who have health insurance. We have it's not very often common, but about 27 cases out of the 200 and some odd cases was a physician or nurse was present at the time of the death. In Oregon, the Oregon Medical Board and the University of Oregon Medical School, at that time our only medical school, and the Oregon Medical Association got together and came up with the guidelines for healthcare professions regarding what you would call the End-of-Life Option Act. And it's a big, long 500-page thing, but I brought for you just a couple little vignettes from it that relate specifically, I think, to the California Medical Board. This is in regarding to professional noncompliance under Chapter 12, and these were co-written by our executive director. If a licensee of the state of Oregon recognizes that there is inappropriate use of the End-of-Life Option Act, she or he must report this to the Oregon Medical Board. And if there's concern about other healthcare professionals, it is incumbent upon licensees in the state of Oregon to report those also to their respective boards. Also, under 12.3, under this guideline, if a health professional has questions about whether end-of-life care has been being appropriately provided, they should consult the staff of the medical board. I do want to compliment, again, Ms. Kirchmeyer and the staff of your California Medical Board for having already put in place and published information regarding your End-of-Life Option Act, and you actually even have, as you probably all know, a little link that citizens of the state of California can contact your board to get information regarding the End-of-Life Option Act. And other Other components of our guidelines are talk about overprescribing and underprescribing. And we were the first state in the union, the medical board, to discipline a physician for underprescribing medication at the end of life. And if individuals have good faith compliance, licensees should not be reported, and this is not unprofessional conduct if licensee is obeying the ORS 127. Now, our Oregon Health Authority, which I think I can't think of the name of it again, in California. Anyway, I talked with our state epidemiologist, who is the one who's responsible for writing the report every year. And she just described the types of concerns that they have. The vast majority of concerns that run into her when she goes through all the reports that physicians and licensees in the state of Oregon are obliged to send in are paperwork problems. They are things like putting the dates down wrong, not documented that they did all the many steps as you go through the process. And so in Oregon, she or her staff investigate those simple problems. And if there seems to be a bigger problem than that, it's then sent on to the Oregon Medical Board, and that's about 2 a year. About 2 cases per year are sent to the Oregon Medical Board. And as I showed you in that one graph, as the number of cases have gradually gone up, that hasn't increased. She still sends in about 2 a year to the Oregon Medical Board. So the Oregon Medical Board does a review of each of these. We're different than you in that we have a medical director. So our medical director is, and I've been a pro tem medical director for our Oregon Medical Board. We look at those. I talked with Ms. Kirchmeier, who objected a bit to our letter of concern approach, but you have a thing that you can do from your board too, so that if a licensee in Oregon makes one of these little paper mistakes, it doesn't go to discipline, it doesn't go to the data bank. We send them a letter and say, there's been an error here. You did the intent of the law, but you didn't do it exactly right. Don't do this again. And then if there are errors that occur again, that would then raise to the level of an investigation, and that has never happened. There's never been, in the 18 years that we've had this law in Oregon, any licensee that's ever been investigated and subsequently disciplined for inappropriate use of our Death with Dignity Act. Is that going to be the case in California? Who knows? But you have, my idea is that it may not be as big a problem as people worry about. So I've tried to compare the two bills. They're very, very, very similar. And if I could, as a non-lawyer, come up with the differences in the two. You have to be a resident of Oregon, but it isn't as specific as it is in California. In California, there are specific things like a driver's license, tax forms, et cetera. In Oregon, we say those could be one, but if you say you're a resident of Oregon, you're a resident of Oregon. People don't move to Oregon just to get this done. There is the case of Brittany Menard, which is, of course, a very, very famous case, but these people are very sick. These are very, very sick people, and they're not really able to come to Oregon, and it won't be something I think that you'll see in California. The attending physician is responsible in California for all the forms, and the attending physician in California must see the patient alone to make sure that they're volitional. The only change there is if there's an interpreter. In Oregon, we don't have any of these rules and regulations regarding an interpreter, and the physician does not need to see the patient alone. The consulting physician in California is called an independent physician. That's not called that in Oregon. And we don't have this thing called a 48-hour attestation form in Oregon. That form is a form that the person who's considering choosing aid in dying must fill out 48 hours approximately before they choose their end-of-life medication, and then that becomes part of the medical record. We don't have that in Oregon. And I don't think it's outlined in the California Act about the death certificate. In Oregon, it is outlined that the aid in dying cannot be written on the death certificate. It can only be the terminal disease, lung cancer, etc. If you write aid in dying or death with dignity on the death certificate in Oregon, you get as a doctor, the doctor gets it back, and you have to put in the terminal diagnosis. And you have a sunset, a 10-year sunset law on yours, so that's going to be reviewed in 10 years, and ours has not. Ours is permanent unless it's voted out, and the other amazing thing about ours is that it hasn't been changed really in 18 years. So I want to bring up a couple special points about your End-of-Life Option Act, about the importance and the value of hospice care and palliative care, and the doctors specifically talking to their patients about that and documenting that, because I'm such a believer in hospice care. Both of these are about that. And then again, that's if you abide by these rules and regulations, there's no any kind of disciplinary action or penalty or criminalization of a doctor prescribing medications. I think you have this in your folder. I just used the phrasing is so similar between what the attending physician is, but it's a little bit different in the consulting physician. You say who is independent, and I asked Ms. Kirchmeier how the staff interprets that, or your legal advice interprets the word independent. Then the attestation form, as I mentioned, you have in California. We do not have that in Oregon. What are the barriers for the citizens of Oregon, which, as you know, is one of the four main tenets of medical ethics, social justice? Main barrier is lack of education by doctors and lack of education about patients, that they have the option and know about this. And then another barrier is that these people are dying, and many of them just don't have 15 days to, when they decide this might be something that they want to do, to go through the whole process. In Oregon, the average or median time for a person who said they would like to consider medical aid in dying and then actually proceeding and going through the whole process is 48 days. And then some places in Oregon, it's impossible to have this happen. We have a town called Roseburg, which is on I-5. Roseburg has a Catholic hospital, and all the physicians' practices are owned by Catholic Church, with the exception of about 3. And they do not allow any of their individual citizens of the state to access this law. So if you are a citizen in Oregon and live in Roseburg and want to consider death with dignity, it's not really very possible. And some medical providers who are opposed to the law have provided patients with misinformation. We've uncovered this, but not to the level of discipline, or delay the patient from starting the process. So this is your wonderful website, which I've been to, and I like it better than ours in Oregon, but don't tell Kathleen Haley that. I think you have a great website, and I know you're going to make it better. I saw that in your earlier presentation. And there's information on your website. So what are some concerns that you might have? And these are the ones I dreamed up, and you probably have different ones. So what is the intent of this law, and how to deal with licensees who violate it? How are you going to deal with the pure paper problems that you have, which will be the vast majority of situations you'll have to review? How are you going to deal with complaints from the citizens, legitimate or non-legitimate? And how does the respond to opponents who may obstruct the citizen of California to have this option? This is a website that the group that I work for now, called Compassion and Choices, has. And this is a website called endoflifeoption.org. And we've made a number of videos for patients and for doctors to consider the clinical practice guidelines for the End-of-Life Option Act in California. 3 of these are on this website that you can see if you would like, or if you could refer to. We have 6 more of them, and we're trying to get continuing medical education through UCLA. And it's just about done. And this just provides clinical practice guidelines for your licensees if they're considering this option or their patients ask them, so they can become educated. So this is the website, our website, that has that. and it says resources for doctors there, the second one on the top. This is the chapters, medical aid in dying and the physician's role, what a physician should consider when responding to a patient's request, the process and liability protections. Those are the 3 chapters that are out in the public now, but the other 6 we're trying to get CME for them. This is a resource for your licensees on the clinical practice guidelines that was written by several authors, a couple of which are at UC Davis. I think Dr. Ben Rich is at UC Davis. And so here are my conclusions for you. It's not common. It's a very uncommon thing, but it is going to be integrated into the California Medical Practice Act, and that you should all learn about it and understand about it. There are barriers that citizens of the state of California will encounter, and the law is not necessarily easy to navigate, whether it's from the citizen or the licensee. We have not uncovered licensees who have violated the intent of the law in our 18 years. And we have had unexpected consequences in Oregon, which we believe have all been good. There's no slippery slope to other changes. There has been no abuse for the disabled or the poor that's ever been uncovered. And we believe it's improved end-of-life care. So that's my presentation for you today. Thank you for listening to me, and how I could respond to any questions, I would be happy to do so. Thank you again.
Thank you, Dr. Grube, and before I go to the rest of the board, I have a couple things. Have you ever done a poll to see what percentage of physicians are willing to participate and how many are not willing to participate in Oregon?
There are many different polls that have been done, and to my knowledge, in Oregon, not specifically in Oregon. There are different polls that have been done nationally. There's a Medscape poll of about 2,000 primary care physicians, and they ask the questions in different kinds of ways. There's been different kinds of polls in the state of California. I know there was one that was done in Berkeley. Of course, the important question is to ask, individuals, doctors who are going to, the subspecialists who are going to be involved in this, not the dermatologists and the pathologists. And so roughly, if I can answer your question roughly and consolidate all those kind of non-parallel polls, approximately 50% of physicians support medical aid in dying, and approximately 30% of physicians are opposed to it, and 20% of physicians don't know what they think. But that's a great question, but of course this isn't about us doctors, really. It's about what the citizens want, what the patients want, and then whether or not we, through professional integrity, could support their wish. So it's a great question. It's about half, I would say.
And the next one is that you showed that about a third of the patients don't follow through. My curiosity on this one is, with the opioid epidemic sweeping the country, you had any trouble somebody else using those drugs?
Great question. So we don't use opiates. That's not one of the main protocols. It's a short-acting barbiturate, secobarbital, which is essentially not used at all. It's not a pain medication. It was originally a sleeping medicine. So opioids really aren't used for end-of-life medications. People who are dying, as you know, I believe you're a surgeon, right? And these people have a whole host of medications in their bathroom as they're dying from their cancer or whatever that are very, very dangerous. And secobarbital, which is a medicine that people take as a aid in dying medication, is dangerous and should be used with great respect. But it's not really in the opioid family, as you know, at all. And there are other protocols. There is an opioid protocol for the opiate naive patient. Very rare dying person who's opiate naive, but there are ALS patients.
Okay. Board members?
Yes.
So my question is, so oftentimes there's discrepancies with someone who says maybe they have a terminal illness, and I know with the most famous case, she lived an additional 6 months with the brain cancer. So how does one reconcile the ethical duty that the doctor has to ensure that it's terminal? You're you're really dying with the fact that you could live? And is there sort of any ethical issue at that stage for prescribing a patient an RX when there's a possibility that they may actually survive? How do you reconcile those things?
This is a great question. Doctors aren't able to exactly say how long a person is going to live. But as I mentioned in these individuals, the vast majority of them are very, 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 very sick and are seeing two doctors, usually a third doctor. They usually have a medical director of a hospice is also involved in their care. So there's quite a whole host of them. If you read Atul Gawande's book, the sad news is that for the most part, doctors over-predict how long a person is going to live. And the worst group is family doctors. So studies have shown that by as much as 500%, we predict that people will live longer than they actually ever do. And my group, I'm a family physician, are the worst at predicting a person's length of life, and it's actually the opposite. We think, and I think you're going to live longer than you actually are. So if a doctor is not confident or sure that this individual has that diagnosis, prescription should not be written. It's not pure science, but these are people that, in my experience, I did have experience with patients. I have written end-of-life medications. All of these people were so sick, there was no question, and a couple of them didn't even make it to the 15 days. So it's not perfect science. I think you, as a California Medical Board, are charged to have licensees who are educated, who understand, and who can do the best that they can to protect the citizens of the state. So they shouldn't be making predictions of end-of-life care, if they aren't sure about it.
Thank you. Mr. Warner.
First, I've had more experience in this issue before the change in the law than I should have, being one of those public members that you talked about rather than a medical member. And I want to thank you for coming to give this presentation. It's very helpful. But my question is basically, are there any mistakes in our law or the Oregon law that the board should be aware of that we need to inform doctors of that there might be traps to fall into?
I have to be careful. I'll take off all my hats now and just speak for myself. I'm not speaking for Oregon Medical Board or Compassionate Choices, just in my own personal experience. The inability of citizens of Oregon to access this law in some areas needs to be looked at, and it really is sad that someone is suffering a horrible, terrible end-of-life situation, and it's legal in the state, but they can't find any source. Should be looked at in some way, and I don't know if that would be this law or another law, but that's the sad thing. It's very rarely used, but the people that need it, who are autonomous, independent, and suffering in such a horrible way, and then they do something more tragic. That would be one thing that I would say. In your California laws is pretty much the same as the Oregon law. I don't think there's too much difference. Main thing might be the independent word. In California, you have that independent word, right? And so I practice in a little town of Philomath, a town of about 2,000. I was there for 35 years. There were two doctors there, me and my practice partner. And we had some very, 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 very sick people dying, and might want to consider this. If they lived in California, Philomath was in California, they would, according to the independent word, they would have to go to a different town to find another doctor. They couldn't talk to my practice partner about it. So I understand why that word was put in the California law, but it bothers me a little bit because I just think about the dying person who it's hard for them to get in the car and go to another town and find another doctor. But that's what's in your law.
Thank you. Dr. Kraus.
Thank you very much for this presentation. It's most valuable. To your knowledge, in any of the states where these laws exist, has there ever been any kind of untoward outcome of proper application of the law?
So do you mean that the person, when they took the fatal medication, didn't die?
No, there's a long list of possible untoward outcomes. It could be an agonal death, could be misuse of the medication by others, could be a inappropriate decision. So anything that could be viewed as untoward, to your knowledge, has that occurred in any of these states?
Well, certainly, there's been 6 in Oregon over the 18 years, and those were years and years ago. There were 6 individuals who took the fatal medication and did not die, and each of those was looked at, and it was discovered why. It was not taken appropriately, or it was taken in association with dairy products, or they had major use of laxatives. So I do know about Oregon more than anywhere else, and there's been no other misuse of medications, abuse of medications, coercion. There's never been any evidence for that. Recall then that these individuals are 19 out of 20 times are in hospice, and they are very connected. I mean, they have a social worker and a chaplain, a nurse, medical director, 2 doctors. So these are not people that are sort of out there that you don't know about them. They're very everything that happens to them is sort of documented somewhere in some AIDS log. So with the exception of the fact that early on there were cases of what's called awakenings, that's the only one of the things that I know of.
Yeah, Dr. Lewis.
Yes, a very, very informative presentation, an area that I think we all try to get our hands around, but don't quite understand what to do. There's lots of comments with, we got to dinner and about the law, and you're concerned about abuse, and maybe you just need 2 physicians, and are you going to put many, into this program, and you just need 2 doctors, so, but it was comforting for me to hear that most of these people are in hospice. So that's sort of a check on, it's a check on the system. It's not perfect, but at least it's a check on the system. My comment is that, and maybe you know this, there are 2 major hospitals in the Palm Springs area. One's for-profit, one's not-for-profit, who have informed their medical staff that they will not permit anybody on the medical staff to participate in such a program. And I'm having trouble understanding why, and maybe you can tell me why we see that or might see more of that.
Well, thank you for asking that question. Again, I'll speak for myself. I think it's because we doctors think about ourselves and we're not listening to what our patients, their needs are. So that had happened in Oregon originally, and we've seen a sort of a slow change where initially the Oregon Hospice Association was opposed to our Death with Dignity Act, and now they have a neutral stance. Initially, the Oregon Medical Association was opposed, and now, like California, they have a neutral stance. There were hospital associations, like the Adventist Hospital Association was opposed, did not allow their doctors. Now they do. Their Cascade Hospice, Benton Hospice, Evergreen Hospice now allow their employees to participate. So you're seeing a change. There's been a real kind of a change in Oregon, and but that isn't like a slippery slope. It's not like what it really is more people realizing that as we advance our technology and get our patients these wonderful cures, they end up having 17 more things wrong, and then they end up having these situations where there's no dignity left in life. They're having intolerable suffering. So I am disappointed to hear that there are big organizations in your state that are saying that their doctors may not participate, and yet what I think you'll see, if it's like Oregon, is that they more and more will participate, with the exception of the religious ones. And if there is, in my opinion, again, an argument against medical aid in dying, that's valid, it is a religious argument. That is absolutely valid. But other arguments for me, having taken care of patients having intolerable suffering and listening to them and caring for them, I believe that your new act is safe and appropriate.
Thank you. Dr. Grube, actually, I think my understanding is California Hospital Association is advising its members to stay off. But remember that California is one state where physicians cannot be directly employed by the hospitals unless they're a public entity like federal, state, or county. So and most of this, the one you're talking about is outpatient stuff anyway. It's not within the hospital. So that's the difference between Oregon. My understanding is can employ doctors. Am I correct? Hospitals.
Yes.
Yeah. So
they do.
So that's the difference between California and Oregon. It was actually came up our own hospital executive committee meeting, and our understanding was that hospital is not willing to participate, but physicians in independent practice can do outside the hospital. So
It's almost, I would say it never has happened, but I would say it's almost never happened that a person has chosen aid in dying in Oregon in a hospital. Right. It just doesn't happen. Right. The final thing I forgot to mention, and I left Ms. Kirchmeier a couple of these brochures, we have a program called Doc to Doc, and so any doctor in California can call a 1-800 number and ask a doctor from Compassionate Choices, and usually it's me, questions about that. And I wanted to assure you, and Ms. Kirchmeier asked me about this, if there's any questions from a California doctor, a licensee that you're responsible for, calls me and is giving me information that I feel would violate the California Medical Practice Act, I would notify the California Medical Board immediately.
thank you. Any other questions? Any public comment on this item? Any comments on the phone?
Do we have any comments on the line?
We have no comments from the phone lines.
Thank you. Thank you, Dr. Grube.
Thank you very much. Thank you.
Now we go to agenda item 5, President's Report. As you know, Mr. Serrano Sewell, the President of the Medical Board, was precluded from attending this meeting due to long-standing commitment. Therefore, I am providing the President's Report. Knowing that he would be unable to attend, Mr. Serrano Sewell provided a written report to the members. It can be found under tab 5 on pages BRD 5.1 and 5.2. Some of the highlights of this report include a few of the board accomplishments over the last 2 years, including the board's legislative day, which I had the privilege of taking part of. On May 11, 2016, myself and 7 other members visited several Senate and Assembly members to educate them on the board and its roles and functions. Several of them agreed to provide outreach about the board to their constituents via social media and websites. I would like to thank the members for their participation. Mr. Serrano Sewell in this report also asked about his 3 top priorities, which included interim suspension orders, a physician health program, and public outreach. We will have updates on each of these items today as well. Finally, Mr. Serrano Sewell discussed the patient notification task force and how the board will move forward on the issue of patient notification of the physicians on probation. More information will be provided by the board's executive director during her report and is also in her written report. Please know that the board takes this issue very seriously and will take up different issues and ideas that have come from the task force in the appropriate standing committee. Regarding board committees, Mr. Serrano Sewell thought that it would be prudent to wait the election of the new officers prior to assigning members to any of the committees. The new board president will work with Ms. Kirchmeier to review committees that need appointment and will make appointments within the next month. If any member is interested in certain committee or changing committees, please let Ms. Kirchmeier know. Over the last quarter, Ms. Serrano Sewell and I have had a call with the board staff to discuss issues and projects at the board as well as the board's agenda. Are there any questions or comments from the board members on President's report from the board members? Seeing none, any public comment from the audience? Any comments on the phone?
Do we have any comments on the line?
We have no comments from the phone lines.
Thank you. So now we'll go to the agenda item 6, board member communications with the interested parties. Any board member has any? Oh, that's quiet. Thank you. Any comment from the audience? Any comment on the phone?
Do we have any comments?
We have no comments from the phone lines.
Oh, we are cruising along. The next item is agenda item 7, executive management report. Ms. Karshmeyer.
Good afternoon, members. I'm not going to be going over the administrative summary, the enforcement program summary, or the licensing program summary unless someone has a question. However, I do have a few things I'd like to point out and bring to your attention. I'd first like to draw the members' attention to page BRD 7A5, which is the governor's budget that passed in June and includes the medical board's budget basically for fiscal year 16-17. On that page, on page BRD 7A6, the board's fund condition indicates that the board's fund reserve is projected to be at 3.6 months at the end of the last fiscal year and below the mandate in fiscal year 17-18. The board has not received month 13 reports yet, so it has not been finalized for fiscal year 15-16, including actual final expenditures that will come in October. Once this is completed, it will identify where the board's fund reserve is at the end of this past fiscal year. I'm happy to report that the board's budget change proposals to hire an additional staff in the central complaint unit and to increase our expert reviewer funding was approved and included in the governor's budget. Staff is working to hire this new position in the complaint unit. The fund condition on page BRD 7A6 also identifies the other BCPs that were approved and shows loan repayment of $6 million in this next fiscal year. As we've done in the past, on pages BRD 7A 18 to 19 is an update from the executive officer of the Board of Pharmacy. Yesterday, I also gave a medical board update at the Board of Pharmacy meeting. We will continue our collaborative efforts and will continue to update each other's boards. And I'll be providing more information on this under agenda item 8. I would like to draw the board's attention to 7B 8 to 13. This has been a long-standing issue, and I am so happy to report that our information technology staff has finalized the requested enforcement reports and has included the information from these reports on those pages. In addition, as promised, the staff has updated the vertical enforcement reports since the reports were placed in the vertical enforcement report released in March. Those reports are on page BRD 7B 14 to 17. All of these reports will continue to be reported from here on a quarterly basis at each board meeting. I would like to point out that the board staff tried to use the same data markers for the reports from the CAS system, which was our old database system, to the new one, the Breeze system. However, based upon the chart on page BRD 7B8, and if you look at that one, you'll see a large jump. I'm not sure that these reports are actually comparing apples to apples. I believe that may be one of the reasons for the increases in time, but we also know that there's been an increase in the number of complaints and the transition to the new system. So we do know, and that's one thing that Ms. Delp spoke about in the enforcement committee, that they're doing overtime to help on that time in that central complaint unit. However, the reports are gathering information we want to show, and that is the time in that central complaint unit from the time a complaint's received until the time it is closed. And therefore, we're going to continue to use these reports, but the starting point might be the best thing to use when we first got this new report and go from there rather than looking at that old data. The difference in the report on page 9 versus those on 10 or 11 are due to the fact that we now want to measure the investigation process separately for sworn staff through the Health Quality Investigation Unit and the time it takes for them versus the time for the non-sworn staff at the medical board. So that's why you see the separation out. So it looks funny because we only go through, I think, October or through 13, 14, and then we stop and it goes to those next two pages. So that's the difference. And from here on out, we're going to just be capturing non-sworn and sworn staff. So those pages will look like that from here on out. In addition, we also now have the information that indicates on page 12 the length of time it takes to file an accusation. We definitely know that this report is actually not comparing the same data pre and post Breeze, because we can now look at cases that are truly AG referrals for an accusation, as to where in the past, when we were looking at it under the CAS system, we actually looked at those also that went for a public letter of reprimand to the board for processing. So these reports truly are just Attorney General time. So that's all of the information on those enforcement charts. That's the first time, and we will be sending those, providing those now on a quarterly basis to the members so you can kind of follow how the enforcement program is doing. A notable statistic for the licensing program is the fact that the board issued 222 more licenses in this fiscal year than the prior fiscal year. In addition, if our numbers are correct, and this is one we're still verifying the information on, it appears that we received 913 more applications this year than in prior years, and that's a huge jump for us. So that's it on all of those reports. I'm going to move into the CARES update unless there's any questions. Okay. In regard to CARES, I want to let the members know that the board really made a push at the end to get individuals registered. We sent weekly emails to physicians who had not registered and even had a countdown clock on our website. Hopefully you all saw that. It was something we stole from the pharmacy board. We received a significant amount of calls the 2 weeks leading up to July 1st, but staff assisted where they could and contacted DOJ in order to assist those that we could not help. As of Monday, there are 71,491 individual physicians registered in the CARES 2.0 system. In addition, there are approximately 32,000 prescribers and dispensers who were in CARES 1.0 but have not updated their information, so we can't identify whether they're a physician or they're another prescriber or dispenser. So that number of 71,000 is actually higher even than that number. This really shows that the outreach by the board and all interested parties really had an impact, and I want to thank the California Medical Association, who also made a push in those last few days to get people registered. I'm currently working with the Department of Justice to identify physicians who have a DEA to prescribe but are not yet registered. Once we identify those physicians, we will send an email and possibly a postcard to them informing them that they need to register into the CARES 2.0. In our most recent newsletter, we also published a FAQ section based upon some questions we were receiving from the calls on CARES. And just to give you an example, we actually got several patient calls that came in that said their physician told them that they were no longer going to be prescribing after July 1st because they had to register in CARES. That's how much misinformation is out there, because I think that the doctors were scared that, oh, now I have to register and now my prescribing is visible. Well, their prescribing's been visible since 1999. It's just now that you can actually, as a physician, get in and see it. So we're trying to nip some of those questions by putting out this FAQ in the newsletter. Another interesting statistic I wanted to pass on about CARES is that from June 25th to July 25th, physicians requested 161,499 patient activity reports. So kind of think about that. In 1 month, over 161,000 patient activity reports. So I do think that registration into CARES has made a huge impact on the doctors who are actually now using it. As I stated at the last meeting, the board is working with the University of California at Davis and the Department of Justice to send a survey regarding the CARES 2.0 system to all physicians whose licenses expired in November, so they're coming up. The survey will be attached with their November renewal that will be sent out next month. The survey is going to ask physicians how CARES 2.0 is working for them and any problems they are having, as well as any suggestions for improvement. Again, this survey is part of a study on opioids and part of a grant work being done by the California Department of Public Health and the Department of Justice. Are there any questions on the CARES? Okay, moving on. I'd like to draw your attention to pages 7E, 1 to 15, which includes not only an update from the Executive Director of the Health Professions Education Foundation, but also the Stephen M. Thompson Loan Repayment Program Annual Report. So since we don't have Dr. Yip is no longer on that board, or on that program, we're actually doing a written report. And again, in Sunset, we're going to try to get medical board members back on that education foundation. Regarding the issue of overprescribing psychotropic medication to foster care children, I'm happy to report that the board received additional information from the Department of Healthcare Services and Department of Social Services on June 13th. That additional information was not exactly what the board had requested based upon our experts' review and her request, but it was the information that they had available in their two systems. The additional information has been provided to our board's expert pediatric psychiatrist. The board is hoping to have a response from that expert in August. We're hopeful that that additional information will allow the expert to identify if there are any physicians who are inappropriately prescribing, so the board can continue through the enforcement process and obtain medical records. And also regarding that, as all of you know, our mantra, and Ms. Simoes and I, in any meeting that we attend regarding this issue, our mantra is that we need to have complaints from those who are in the system. The social worker, the nurse, the public health advisor, all of those individuals that are in that system, if they see an individual who's inappropriately prescribing, we really want them to prescribe. In that regard, recently, Ms. Delp has actually attended, and will be attending actually in the future. We requested to be on the agenda. She did a really good job pushing for this. So she's going to be doing a 10 to 15-minute presentation at the next Quality Improvement Project meeting on our enforcement process and how to make a complaint. And we've actually done a shortened version where individuals in that system can actually call her and Ms. Romero and make a complaint rather than having to go through the whole complaint process with the documents that we have. And so we're going to be talking about that. And again, it's just to encourage those in the system who truly see these individuals who are inappropriately prescribing so they can make a complaint. One Breeze update I would like to bring to your attention is that, yes, as of yesterday, the ability to subscribe, actually it was done at midnight last night, so it was starting this morning. The ability to subscribe to a change in a licensee's primary license status was turned on. This means that an individual can go into Breeze and sign up to receive a notification when a licensee's primary status is changed. So for example, if your physician's status went from renewed and current to revoked, the Breeze system would send that subscriber an email saying the status has changed from renewed and current to revocation. This was something that came up during our discussions on the patient notification. I also wanted to let the members know that, as most of you know, Hetty Chang in the past had been our FSMB representative, and then it changed to Dr. Watson, and now we have actually changed to Dr. Steingard, who is from the Arizona Osteopathic Medical Board, and he actually is going to be our new liaison. So that's the only update really I have on the Federation. Lastly, as Dr. Gonadev stated, I would like to draw the members' attention to pages 7A, 3, and 4 regarding the Patient Notification Task Force. After discussions with the board president and vice president, it was determined that the issues from the task force will be pursued under the appropriate standing committee. The information regarding these issues are listed on the 2 pages, but I'm just going to summarize. The outreach and website changes will be pursued within the Public Outreach, Education, and Wellness Committee. The signage and changes in legislation to allow the board to require more information that on the sign a physician must post will be pursued through the board's sunset report. And lastly, the issue of a possible change to the disciplinary guidelines to have an optional condition that would require a physician to notify their patients they are on probation will be studied under the board's enforcement committee. While the change to add this condition to the guidelines can be done through the regulatory process, the mechanics of how that notification would occur is something that needs to be looked in and fully discussed with all interested parties, because as you know, that was a lot of the concerns that were brought up by everybody in the room on this issue. That concludes my report. Are there any questions?
Thank you, Ms. Kirschmeyer. Any questions from the board? Any public comment? Any comment on the phone?
Do we have comments on the line?
Yes, we turn to the line of Genevieve Clairbrule. Please go ahead. Your line is open.
Sorry?
We have a call.
Go ahead.
Genevieve, go ahead.
Oh, Genevieve, okay.
And Ms. Clareborough, you might have your phone on mute.
You ever met Genevieve? I don't think you've seen Genevieve. She wasn't here last time. Genevieve's quite a character. She's a regular.
Genevieve, are you there? What's going on?
Hello.
There you go.
Hello.
Yes, it's about the statement about cures. I think some of the physicians are not very skilled at using it, and yes. Yeah. Anyway, I had issue recently. I'm not going to discuss it because I just sent you a. Yes. Can you hear me?
Yes, we can hear you.
Can you hear me?
Yeah, we can.
Yes. I think a lot of the physicians still don't know how to use the cure system well. Anyway, I have sent you a formal complaint, so I'm not going to speak on it now, but I think it's still an issue on how skilled some of the physicians are to utilize cure.
Thank you.
Thank you, Genevieve. Actually, we miss you. Take good care of your health.
Yeah, I send it today. Okay. Have a good day. Thank you for listening.
Thank you.
Any other comments on the phone?
Any additional comments on the line?
We have no further comments in queue on the phone.
Okay. Thank you. And moving to agenda item 8, discussion on collaboration with the Osteopathic Medical Board of California, Board of Registered Nursing, Board of Pharmacy, and Physician Assistant Board. Ms. Kirschmeyer.
So this one will be a lot shorter. At the last meeting, a member requested that board staff look into meeting with the Board of Registered Nursing and the Board of Pharmacy on issues of mutual concern. This collaboration is very similar to what is occurring at the national level. At the national level, they are looking at successful team building, new practice models, and communication ethics. And as you all know, there was a tri-regulator meeting between the National, the Federation of State Medical Boards and the National Association of Nursing, or Nurses, and then also the boards, National Boards of Pharmacy. So while thinking about starting this collaboration, I determined that we should not only be meeting with the boards of pharmacy and registered nursing, but also the board of osteopathic physicians and the physician's assistant board. In several states, these licensees are all under one board, but that's not the case here in California. This is a great opportunity to bring these boards together to work on issues that impact each one of us. I've already reached out to the executive officers of each of these boards, and they're all very excited to meet. I'm in the process of setting up meetings with the executive officers in August. Some of the issues identified which to discuss are collaborative care, telemedicine, CARES usage, and the opioid epidemic. Once we get the discussions going, it may be valuable to have 1 to 2 board members from each of the boards also get together. I think some outcomes of the group could be education on certain issues and a united front on issues such as the opioid misuse and abuse. Once the initial meeting takes place, I'll provide the members with an update. This is a very exciting endeavor, and the director of the Department of Consumer Affairs has also offered to attend and assist in any way necessary to move this collaboration forward. This is a partnership is very important in the era with telemedicine and technology and medicine both evolving. And again, if you're interested in being on that collaborative, I'd really appreciate you to let me know, and I can discuss that with the new board president. Working together would also lead to enhanced consumer protection. Are there any questions on that?
Thank you, Ms. Kirschmeyer. Actually, this came about when 3 of us attended the FSMB meeting in San Diego, and Ms. Kirschmeyer were there with the states where they're doing, there was some significant collaboration. We thought that would really help working together with all these boards. Thanks for looking into it. Any questions from the board members? Any public comment? Any comments from the phone?
Do we have any comments on the line?
Yes, we do. We turn to the line of Genevieve Clareborough. Please go ahead. Your line is open.
Yes. Please, I would like to be kept informed of that team approach. I have been very involved for a long time, and I would like to be one of the members of the public to be involved in it. So please keep me posted. Thank you.
Thank you.
Thank you.
Any other comments?
Any additional comments on the line?
We have no further questions in queue.
Thank you. Moving to agenda item 9, update on the sunset review process. Ms. Kirschmeyer.
On July 8th, the board received its Sunset Report questionnaire. That document can be found on pages BRD 91 to 15. Per the memo from the legislature, this process allows the legislature to review the laws and regulations pertaining to the board and evaluate its programs and policies, to also determine whether the board operates and enforces its regulatory responsibilities and is carrying out statutory duties. It's also there to examine fiscal management practices and financial relationships with other agencies. Boards are also evaluated on key performance measures and targets related to the timeliness of action, enforcement, and other necessary efforts to serve the needs of California consumers while promoting regulatory efficiency and effectiveness. The report form must be completed by December 1st of 2016. And just to give you an idea, I don't think it will be like this year, but in the past, the last time we did it, our document was 4 volumes, and each volume was about a ream of paper. So we have a lot of work ahead of us, everyone. The first sections of the report provide an overview of the board's current regulatory program, and the latter sections focus on responses by the board to particular issues raised by the board or raised during the Sunset Oversight Review. The report serves as the basis for the background paper legislative staff will prepare. The board was informed that the Senate Business and Professions Committee will announce the dates for Sunset Oversight Review hearings in early 2017. Board staff has put together a matrix identifying who is responsible within the staff for the questions within the report and their due dates. Ms. Robinson, who spoke earlier today, will again lead the drafting and compiling of all of the information in order to complete the document. One of the hardest parts of completing the report is the writing and compiling of statistics required for the report. So our information technology unit is going to be working with us to get all of the reports we need, because if you look at that, you'll see a lot of the charts are very specific statistics. I'll be working with the board's president to identify a 2-member task force to assist staff with the completion of the Sunset Review report. If anyone is interested in assisting, please let me know as soon as possible. While we hope to be able to present a draft at the October board meeting, it may be necessary to hold a November teleconference meeting to finalize the report due to the lateness of the receipt of the report and the later due date. Since the report was done just 4 years ago and several of the questions just need updates from the last 4 years, this may not be necessary. We do want to provide the members with as much possible time to review the report and to provide comments. It may also require, if we don't do the one in November, it may require us to do an afternoon at the October meeting, a Wednesday afternoon, to review the report. I don't know that that's going to be necessary, though, because we've actually already identified the new issues and you've already approved those to move forward. And our last time, what took a lot of time is going through each of the new issues and identifying whether we wanted to do them or not. So you've already done that. So we're already ahead of the ballgame on that one. Staff will work with the board president on the details of this review process. Are there any questions? And again, I really am looking for 2 individuals who really want to be committed to this report and help us walk through this so they can kind of be our eyes and ears of the board prior to it bringing it to the full board.
Thank you, Ms. Kirschmeyer. Any questions to Ms. Kirschmeyer? Any public comment?
We have one public comment.
Okay. Carol Moss.
Hello. I'm Carol Moss, and I'm here on behalf of the Consumers Union Safe Patient Project, a nationwide campaign that is organizing patient safety advocates from across the country, in California and throughout the nation. We recommend that the board raise the following issues with the legislator as part of the Sunset Review. review process, improvements to patient safety in outpatient surgery settings. Outreach by the board related to physician discipline needs change to the medical board's statute of limitations, and reports of actions taken by hospitals and clinics in the 805.01 reporting. Physician-owned outpatient surgery settings. Hundreds of thousands of surgeries are being performed in California at physician-owned surgery centers. When many outpatient surgery centers were brought under the purview of the MBC, of the medical board, due to a 2007 court decision, Capon versus Sharif, requirements for these surgery centers to report data regarding procedures to the Office of the Statewide Health Planning and Development were removed. We recommend that outpatient surgery settings under the medical board's purview will be required to report a standard and robust set of data to the Office of the Statewide Health Planning and Development. We also recommend this for settings outside of the medical board purview. Outpatient surgery settings are required by law to report adverse events to the medical board. The law authorizes the medical board to fine physicians who fail to report adverse events in a timely manner. We recommend that the medical board post on its website the adverse events reports it receives from outpatient surgery settings and any fines assessed. This information should be posted within the profile page of each relevant surgery setting. Current law says consumer groups and journalists who request hospital adverse event information from the California Department of Public Health may have it. Consumers Union and other media outlets have regularly requested and received this information. We recommend the medical
Please
board do the
conclude.
same. We recommend the medical board do the same in outpatient medical settings. Revise signs in doctor's offices. We ask that you add notification of the phone number of who the medical board is and how they can be reached. Many patients don't know that you're the governing body. We also ask that there's a statute of limitations on filing. We know that the statute of limitations on filing complaints against doctors are greatly affected, and we ask that even cases where the medical board has found extreme departure from the standard of care can be closed, allowing physicians who have violated their licensing standards to continue to practice. So we asked you to review that as well. We thank you for consideration, and we appreciate all the work that you guys are doing. We're really excited to see what happens in the coming year.
Thank you, Ms. Moss. Any other public comment? Comments on the phone?
Do we have any comments on the line?
We have no comments on the phone lines.
Thank you. Let's go to item 10, update from the Department of Consumer Affairs. Ms. Lally. We'll be nice to you, Christine.
Promise. I have a breeze update. Good afternoon, Vice President, members. Thank you again and always for the opportunity to be with you. Christine Lally, Deputy Director of Board and Bureau Relations with the Department of Consumer Affairs. Want to update the board on several important items since our last your last meeting in May. First, I'd like to update you on changes to the department's executive team. In May, as you may remember, after 18 years, I aged our 8 years with the department. Tracy Ryan, our Chief Deputy Director, accepted another position with the Rural County Representatives of California. Then in late June, Governor Brown appointed Jeffrey Mason as our new Chief Deputy Director. Jeff has been with the department since 2013, serving as Chief of the Bureau of Security and Investigative Services, and most recently he served as the Chief Deputy Commissioner for the Bureau of Real Estate. Jeff was sworn into office just 2 weeks ago, so he's in his third week on the job, and we're very excited to have him on board. Also in May, Melinda McLean, as you also may remember, was our Deputy Director for Legislation. Melinda went on to accept a new position with the governor's office, so we're very proud of her. And just last week, again, the governor made an appointment of a new Deputy Director for Legislation, and that's Adam Quinones. You may remember his name because he previously served as the Assistant Deputy Director for Legislation for the department, and he worked very closely with Melinda. So we're very excited for both Jeff and Adam in their new positions at the department. Next, wanted to update the board on some organizational development at the department. As you may know, the department's Solid Training and Planning Solution Unit is specifically dedicated to the department's organizational development and offers a wide array of services to all of DCA's boards and bureaus. Solid recently hosted its second Executive Officer Brown Bag Gathering, and that happened on July 20th. These meetings provide an opportunity to strengthen networking among the department's executives, as well as time to discuss cross-cutting issues and receive peer input on challenges faced in the workplace. It also provides us at DCA a chance to solicit feedback on what other leadership development activities we can provide our executives. Feedback from the executive officers participating at the first two Brown Bag gatherings has been very positive, so we're hopeful on this new program. Also, at last week's gathering, the department introduced a new program we are very excited about, and that's our Future Leadership Development Program. We believe it's critical to enhance the skills of our next generation of executives at the department. This program has three components. First, it specializes in training. Second, mentoring opportunities from the DCA executive team as well as other executive officers. And finally, a group project designed to assist boards and bureaus in addressing common challenges. The group project gives staff the ability to build new skills and knowledge, as well as interact and collaborate with high-performing peers from other boards. There will be a steering committee of executive officers that will assist the department with this new program. Again, we received valuable feedback from those in attendance at last week's meeting on this new adventure that we're both working on, and we look forward to implementing this program together by the end of this year. This new program is an excellent example of how the executive officer Brown Bag gatherings are already providing us unique opportunities for collaboration to address needs department-wide. The department has also officially launched the Employee Career Empowerment and Mentorship Pilot. This pilot, Mentors Submit, and Kim's smiling because she's helping us with it, thank you. Mentors submit profiles that include short biographies, their availability for mentorship, and topics that they're willing to discuss. Our Solid team posts the profiles on the department's intranet, and staff review the profiles and schedule meetings with the mentors. The pilot affords staff a great deal of flexibility to learn from various participating managers. In early 2017, our Solid team will conduct an evaluation of the pilot to look for possible improvements and determine whether we should expand it. There are currently 8 DCA boards and programs participating in this new pilot, and again, we want to thank Kim and her staff for being one of them. Also, on the employee front at the department, in an effort to complement the mentorship pilot, our Solid training team has also developed the Lunch and Learn class series. This is a new component of the DCA Connect training series to encourage our staff within various classifications to engage one another on interesting topics. The sessions are held once a month during 1-hour lunch breaks. In a roundtable setting, DCA employees learn from one another through active listening, effective communication, and understanding another's viewpoint. The facilitated conversations have been engaging, informative, and from what I hear, very lively. Topics have included what does professionalism mean to you, and change your perspective, change your life. We again thank the medical board staff for participating in the Lunch and Learn series. The next meeting is titled Honoring Cultural Diversity, and it is scheduled for August 25th. The Solid team is obviously very busy, but they're also specifically helping Director Kadani and the executive team to develop our new strategic plan, which will span the years of 2017 through 2019. I wanted to bring this to your attention because we will be soliciting input from stakeholders, including all of our board members, executive officers, and all employees at the department to help us identify the department's goals for the next 2 years. An electronic survey from the department will be sent out to all of you and all stakeholders in late August. Your feedback is vital, and we respectfully ask for your participation to assist us in improving the department's services and ultimately our oversight. Finally, I always leave our favorite topic to the end. I wanted to quickly just give you an update on the BREEZE system and specific statistics pertaining to the board, as I know you're very interested in always hearing about how the BREEZE system is performing. The medical board continues to see a high volume of applications submitted online in May and June, and unfortunately our IT team doesn't have the statistics for July available just yet, but the board, in the 2 months of May and June, the board received over 8,886 applications online. For applications requiring a payment, this represents approximately 58% of the total board application volume for this period. Renewals continue to make up a majority of the board applications received online. 8,251 were received in May and June, and of those individuals who renewed online, 98% of them renewed the very same day. So that's incredible efficiency. As of this week, the department has processed over $208 million via the BREEZE online system since the Med Board and the first 10 boards went live in October 2013. Since go live specifically for the medical board, you have processed over $100 million via the online BREEZE portal, so congratulations. Next, wanted to touch base just on the maintenance releases, which Kim just updated you on, and that's a great improvement on the notification, the subscription. But for calendar year 2015, so last year there was an average of 73 fixes that were deployed in the BREEZE scheduled maintenance releases. And since the launch of Release 2 onto the BREEZE system, which was earlier this year in January, an average of 167 fixes have been deployed in each scheduled maintenance release. And this is more than obviously double than the average rate from last year. The scheduled maintenance releases occur every 6 to 7 weeks for the boards and bureaus on the BREEZE system. And a maintenance release of 161 changes, including the one that Kim updated you on today, 161 changes occurred just yesterday. The next scheduled maintenance release will happen in September. And finally, just wanted to update you on the BREEZE license lookup survey. The department is currently conducting a survey to collect public feedback on the Verify a License feature that's available on the BREEZE page. We encourage the board and board members to share this survey with your stakeholders, as we definitely want to get a diverse set of participants to assist the department in determining potential updates to the Verify a License feature in the BREEZE system. This survey that we're conducting started on June 1st and it ends on August 31. As of this week, we've received approximately 5,000 responses to the BREEZE lookup survey. And the way you can get on it too, if you go to the BREEZE site and do a license lookup, you'll get a random selection to participate in the survey. So if you do it enough, you should, it should pop up. Comments received thus far have been very positive, and they're providing constructive criticism, which I know our vice president has been very vocal on wanting to update the Verify a License page. So with the board's help as well as feedback from the survey, we hope to have a good consensus of the changes that would be helpful to the public in updating that page. So that continues to be a high priority for us. So with that, I will thank you again for the opportunity.
Thank you, Ms. Lally. 98% is just amazing. I mean, it's not that we're tired of complaining about it, but actually, there are no anecdotal reports from me, doctor coming and telling me that he or she can't renew their license. They are stuck. That used to be a very common practice before. I haven't heard that in the past few months.
That's excellent. Good.
And I hope that the same thing the consumers can find for looking up their doctors and really see wherever they need to go. I think that's plus one major advantage we'll have with the system when it finally looks like bugs are we're taking care of the bugs. You can do so much research. It's unbelievable amount what the European country people present at the national meetings, what they can do with their with the physician licenses, what's the percentage of probations and revocations, all kind of stuff, which is difficult for us. It's a manual thing right now.
Mm-hmm.
Any comments or questions to Ms. Lally from the board members? Oh, Christine, you're going getting off easy. Any public comment? Any comments on the phone?
Do we have any comments on the line?
We have no comments from the phone lines.
Thank you, Ms. Lally.
Thank you.
Okay, we go to item number 11, update, discussion, and possible action and recommendations from the Enforcement Committee. Dr. Yip.
Thank you. We met this afternoon at 1:20 p.m. The staff provides serious enforcement update. Training with the Office Administrative Hearing will resume this fall with training to be held in September, October, and November regarding emergency room procedures, comorbid patients, and fitness for duty evaluations. At the conclusion of the training, the board staff would provide 6 training sessions to the administrative law judge. Ms. Staff also report that the Central Complaint Unit has decreased the average number of days to process a complaint from 162 days to 146 days, and management continues to identify ways to streamline the complaint process. Ms. Staff also report the enforcement program currently has 6 vacancies, and efforts to hire new staff are ongoing. The vacancies are expected to be filled by September 30th, 2016, right? Ms. Robinson gave an update to the demographic study and report that she and Ms. Kurtmeyer met with the California Research Bureau's senior policy analyst who is conducting the study. The analyst informed Ms. Robinson and Ms. Kurtmeyer that the Bureau will be ready to present the findings of the study at the October board meeting, and one of our committee members, Dr. Krause, has been actively involved with that. Ms. Depp gave a presentation on what recruitment efforts staff in the expert review program are doing to recruit more experts. Ms. Depp provided a 3-stage plan that includes updating the board's website and newspaper, as well as creating a recruitment brochure and public service announcement videos to entice more physicians and surgeons to participate in the program. Ms. Depp also stated 2 expert review training events are tentatively scheduled for October 8th at UC San Francisco and November 5th at the UC Los Angeles. I'm also trying to set the day in the spring with the USC in Southern California, sometime in March, April, and May. Ms. Castro from the Attorney General Office Health Quality Enforcement Section gave an overview of the vertical enforcement process, and we're pleased to hear that her staff worked tireless overtime and with passion and low pay too. Mr. Chris and Ms. Nichols from the Department's Health Quality Investigation Unit gave an update regarding what efforts HQIU is doing to hire more sworn investigators. To mitigate the vacancy issue, HQIU will be hiring some non-sworn investigators and investigation assistants to handle the less complex cases, and psychology and osteopathic board cases will be investigated by the staff in the Investigation Enforcement Unit on a temporary basis until the vacancies are filled. Lastly, Ms. Stout and Ms. Houston give a thorough presentation about the actions probation staff takes when a probationer violates a condition of his or her probation and the time frame for staff to act on the violations. Enforcement committee members, which I'm lucky to have, both are very committed and smart. Dr. Boland and Dr. Krause state They would like to see as a future agenda items the presentation on the quality indicators and quality assurance efforts, a measure of how we improve on the process regarding the actions taken by the probation staff to act when a violation of probation identified. So that concludes the meeting today.
Thank you, Dr. Ip. Any comments? Yes, Ms. Wright.
I think this might be appropriate within the purview of the Enforcement Committee before I bring it up to the full board, but understanding that the Medical Practice Act says that our primary purpose is public protection, I heard at least 6 people speak on SB 277 today, and one of the comments was that potentially doctors are getting kickbacks from insurance companies to do a workaround to still give an immunization to children who aren't supposed to have them. I'd be interested to see if we can get someone either from Senator Pan's office and/or if staff could look into these accusations, because if so, that seems to me that there would be a serious ethical violation. But at any rate, I would still like to hear someone from Senator Pan's office come and speak to some of the issues that we heard raised by some of the public members as it relates to some of the health concerns that they have in terms of history of their children and the immunizations. And I think it was Santa Barbara that has some kind of process that they're using to work around that. I would like to see that. If it's not in the Enforcement Committee, then at the public, at our full board meeting. Emphasis on Senator Pan's office coming to our meeting, since we did, as a majority of the board, decide to support this, minus the 2 abstentions.
Thank you, Ms. Wright. Any other comments? Public comment, I have one. Carol Moss. Ms. Moss.
Thank you again. Yes, my name is Carol Moss, and I'm here again with the Consumers Union Safe Patient Project, nationwide campaign that's organizing patient safety throughout the U.S. and in California. Earlier today, we presented the same discussion here to the Enforcement Committee on the recommendation that the board amend these guidelines to require physicians on probation for serious issues to inform their patients of their probationary status. The presentation today was great on the things that are going to be coming up. So we think that this is very important. Unfortunately, many California patients have no idea. They're unknowingly receiving health services from physicians who have been placed on probation for a range of offenses, including substance abuse, sexual misconduct, violence, patient death, incompetence, gross negligence, and repeated negligent acts. When the medical board allows these physicians to continue practicing medicine while on probation, the physician should be notified. They should let their patients know so they can be aware of why they're on probation. Certainly the patients also have the right to know, as the insurance companies and the medical board and the hospitals. According to the published research and the medical board's own data, physicians on probation are much more likely to require further discipline than physicians who were never disciplined. We also recommend that the patient notification requirement for physicians who are ordered on probation more than one time. We recommend that the medical board demonstrate its commitment to the patient safety by amending its disciplinary guidelines to require, as a standard condition, the physician whose probation is associated with a certain serious violation and practices restrictions be required to disclose their probationary and practice restrictions to their patients. In addition, to help people understand why the physicians have been placed on probation and to fulfill the medical board's stated principle that all consumers should know the history, the disciplinary action, and any healthcare provider they may consider seeing, the medical board ordered the summary. The summary should cover the causes, the probation, and including the accusations of those which the physicians is stipulated, the length of the probation, and all practice restrictions placed on physicians. The summary should also include in the first section the decision and order of probation in plain view, in easy language in Breeze in the webpage, and on any other medical board documents informing the public of probation orders and newsletters, including public records request. The medical board should also amend the current disciplinary guidelines that make patient notification an optional condition in all probation cases. The medical board should develop an effective process to ensure the enforcement of the disclosure of this requirement. And we thank you for all your hard work, and we look forward to seeing all the great changes next year.
Thank you, Ms. Moss. Any other public comment? Any comments on the phone?
Do we have any comments on the line?
We have no comments on the phone lines.
Thank you. The next item is item number 12, update from the AG's office. Ms. Castro.
Thank you. I'm happy to report we have a new Deputy Attorney General in our San Francisco office. His name is Keith Shaw, and he joins us from the Sonoma County District Attorney's Office. We continue to meet with Ms. Delp and Ms. Kirchmeier to find improvements in all of our processes. We really enjoy working with both of them and their respective staffs, and we have nothing but the utmost respect for them and all their big mission that they have to accomplish, and they always do it with a smile. We look forward to assisting in any way that we're asked on the Sunset Review report as it pertains to our role in your enforcement and licensing functions. SB 467 has been enacted into law in Business and Professions Code Section 312.2, and it will require the Attorney General's office to file annual reports with the legislature regarding our performance metrics at the Attorney General's office following the presentation of any transmitted case. And this applies for all of our clients. And so the metrics that will be measured are filing metrics and subsequent averages for important milestones in the life of those administrative cases we do work. We welcome the transparency and accountability, and this report will actually apply to every single DCA client agency, commission, board, and it also applies to the licensing section in my office, which mostly handles non-health care related DCA client agencies, such as smog technicians. They do handle nurses, dentists, and veterinarians, but in contrast to our section, we're 100% health-related client agency work. Our first report will be filed on January 1st, 2017 for statistics related to fiscal year 15-16. So that started already in July 1st. With SB 467, the Attorney General's office joins the Office of Administrative Hearings in our mutually beneficial responsibilities in this whole process for consumer protection, and we welcome the metrics. And so now that we will have metrics from the Office of Administrative Hearings, together with metrics from the Attorney General's office, and of course, all the Sunset Review hearings and annual reports that you as boards and all of my other clients file, we will be able to see the true and full picture, nose to tail, so to speak. And with that, I conclude my remarks.
Thank you, Ms. Castro. Any questions for Ms. Castro? Any public comment? Any comments from on the phone?
Do we have any comments on the line? Are there any comments on the line?
I'm sorry, there are no comments on the phone lines.
They all went home. Thank you, Ms. Castro. Then we'll go to the next item, item number 13, update from the Physician Assistant Board, Dr. Bishop.
Thank you very much. The last board meeting occurred on July 11th. At that time, we introduced a new member who was appointed by Governor Brown, Jennifer Carlquist, and she has extensive experience in the physician assistant world, and we're appreciating her experience on the board. With respect to Breeze, a new online version of the PA application for licensure was added to Breeze in June 17, 2016. And in summary, this new licensing application has enhancements and features which will streamline the process for the applicants. With respect to cures, as we've talked today, all practitioners were required to register before July 1, 2016. In an attempt to achieve that with the PA board, the board updated the website with a Cures countdown calendar and also sent a notification blast to our email subscribers regarding the Cures registration deadline. With respect to the End of Life Options Act, Assembly Bill AB 15, which became effective June 9th, 2016, the board developed an information bulletin for physician assistants regarding the act. The bulletin states the specific requirements of the End of Life Option Act and may only be performed by the patient's attending physician and not delegated to the physician assistant. The bulletin has been posted on the board's website. With respect to rulemaking to repeal Title 16 California Code of Regulations, Section 1399.531 and 1399.532. At the April 18, 2016 board meeting, there was general consensus that the board may wish to examine repealing Title 16 California Code of Regulations, Section 1399.531, curriculum requirements for an approved program for primary care physician assistants in Section 1399.532, requirements for an approved program for the specialty training of physician assistants. The board currently delegates authority to ARCPA to approve physician assistant training programs. Postgraduate specialty physician assistant training programs approved under Section 1399.532 provide training to licensed physician assistants to enhance their current skills. The board does not issue an additional license to individuals who participate in specialty physician assistant training programs. Additionally, since postgraduate specialty physician assistant training programs are training licensed physician assistants, and those students are subject to the same requirements as licensees who have not participated in a postgraduate specialty program, the board believes that there is no need to continue to approve these types of programs. After discussion on this item, the board voted to repeal Title 16 CCR Sections 1399.531 and 1399.532. With respect to Title 16 California Code of Regulations, Section 1399.540, subsection B, Delegation of Services Agreement, electronic signatures. The board continues to discuss the now widespread practice of the use of electronic signatures in patient records and other documents utilized in the medical environment. The board recognizes that electronic signatures allow for the more efficient use of medical practitioners, thus improving care. At the board's April meeting, members voted to request that staff develop proposed amendments which would include the use of electronic signatures in the Delegation of Services Agreement for possible initiation of a rulemaking file to amend Section 1399.54, subsection B. Legal counsel reported that they continue to research the use of electronic signatures to assist in drafting amendments to Section 1399.540. Although this seems like a simple process, it's very complicated because, especially in emergency departments, where a single physician assistant may be supervised by more than one attending physician. So it becomes very complex to make sure that this clearly identifies who the responsible physician is. At the meeting, there was a presentation by the Health Professions Education Foundation regarding scholarship and loan repayment programs. Norlin S. Asprick, excuse me, Director of Marketing and Outreach for the Health Professions Education Foundation, which is part of the Office of Statewide Health Planning and Development, OSHPD, gave a presentation about the foundation and the scholarships and loan repayment programs offered to healthcare students and recent graduates, including physician's assistants. Pardon me, let me get some water here. Thank you. At a recent board meeting, it was noted that the state of Georgia recently passed legislation providing tax deductions for physicians who serve as community-based faculty physician for medical corps clerkship provided by the community-based faculty. In other words, physicians who served as a preceptor for the education of mid-level healthcare providers, such as physician assistants. The board discussed the possible need for tax incentives for physician assistant preceptors. This clinical instruction may come from other PAs or physicians who are not generally paid for their time, but may receive CME credit for being preceptors. Therefore, it is often difficult to find healthcare providers to be preceptors because they are not financially reimbursed. To further explore this concept, the board will hold stakeholder meetings to determine if there's a need to seek legislation. And finally, once again, the PA board would like to thank the medical board, your executive officer, and staff for your continued support. The next scheduled physician assistant board meeting is October 24, 2016. Thank you.
Thank you, Dr. Bishop. Any questions to Dr. Bishop? Any public comment? Any comments on the phone?
Do we have any comments on the line?
And we have no comments on the phone lines.
Thank you. Mike, I know it's just a little too early, but how is the breeze for the PAs working out in a 1 or 2 months?
I'm sorry, we haven't heard any major complaints. Seems to be working out quite well, as a matter of fact.
Yeah. So we were the experimentees, Ms. Lally. We fixed all the stuff and they're all fine. So with that, we'll go to the last item today. Oh, thank God. Agenda item 14, election of officers. I would like to ask for the nominations for the Secretary of Medical Board of California. Can I have a nomination? Yes, Dr. Kraus.
This is actually more difficult than it would seem, because having served on this board for a few years, I am firmly convinced that everyone who is sitting here would be a fine executive officer. Nonetheless, I would like to nominate Ron Lewis for secretary.
Dr. Lewis, you're okay with it, I gather.
I accept, thank you.
Any other nominations? If not, Lisa, please.
Dr. Bolat?
Aye.
Dr. Bishop?
Aye.
Judge Feinstein?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Ms. Lawson?
Aye.
Ms. Sutton Wills?
Yes.
Mr. Wormuth?
Aye.
Ms. Wright?
Yes.
Dr. Yip? Dr. Gonadev?
Aye. The next one is, I'd like to ask the nominations for the Vice President. Dr. Kraus.
I've actually spent quite a bit of time thinking about our leadership, and I wish that she could have been here today, but our board member Denise Pines, I think would be incredible as our Vice President, and I think that she's willing to accept the nomination, and I'd like to put her name forward for that.
Thank you. Any other nominations? I can vouch for Dr. Ms. Pines too. She's a wonderful person. Ms. Toof.
Dr. Bolat?
Aye.
Dr. Bishop?
Aye.
Judge Feinstein?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Ms. Lawson?
Aye.
Dr. Lewis?
Aye.
Ms. Sutton Wills?
Yes.
Mr. Wormuth?
Aye.
Ms. Wright?
Aye.
Dr. Yip? Dr. Gonadev?
Aye. The last one is, I would like to ask for nominations for the President. Dr. Kraus.
This nomination causes me great personal discomfort. And I must reveal a conflict of interest because I had a acquaintanceship and friendship and high regard for this individual prior to our service on the board. But I'd like to nominate Dr. Deb Gnanadev.
I don't even know if we can conduct this election, but any other nominations? If there is any, I would recluse myself and leave. I think I'm doing the right thing, so if not, Ms. Toof.
Dr. Bolat?
Aye.
Dr. Bishop?
Aye.
Judge Feinstein?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Ms. Lawson?
Aye.
Dr. Lewis?
Aye, aye.
Ms. Sutton Wills?
Yes.
Mr. Wormuth?
Aye.
Ms. Wright?
Aye.
Dr. Yip?
Thank you. That concludes the meeting for today, and I do actually want to thank the board members for your confidence in the executive, in the officers for the medical board, and as I can mention to you now that any one of you who is interested in any committee, please feel free to call Ms. Karshmeyer or I. We're going to revamp all the committees within a month. With that, we'll have the meeting adjourned till 9 a.m. tomorrow morning.